Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Recato of Recato Law, a small law firm in central Minnesota. With me today, joining is a very special guest. He's been on the show before, but it's been a minute. And we've got some pretty exciting stuff to talk about, in my humble opinion. This is attorney Matt Wilson. How you doing, man?
I'm doing pretty good. Thank you for having me on the show, Nick. I appreciate it.
Of course. It's always good to have practicing attorneys on the show.
Well, if you want to, I suppose you could say I'm practicing. We always practice, right? I mean, it's...
Well, you do. I made perfect, so I don't have to anymore.
By the way, I got to tell you something. When I first came on your show, it was during the Kyle Rittenhouse thing. I remember I was on the panel when we were doing the last few days of the trial. I think it was mainly just oral arguments. Yeah. And I had just moved into this house, and I hardly knew the neighbors. And then I finished the show, and I walk outside and find out that my next door neighbor was, watching the show that was going on.
He's like, "That's you."
Yes, I mean, he was like that. So if he's watching, he knows who he is. So thanks for keeping an eye on the house while we're gone. But yeah. I mean, it's just an honor to be back on the show. I enjoy being up here with you, and you're a hoot, and everybody you have on the show, I like that. So
yeah, man. Well, thank you. And since the last time you were on, you actually have. I mean, we're going to get into the crazy stuff that's going on right now with Donald Trump. All of the political prosecution going on, all of these lawsuits. We're going to talk about Nathan Wade and Fani Willis, of course. But for just a second, I have to point out that, guys, this is the man who defeated the undefeatable Critical K. the unstoppable, the inimitable Karen Yax was destroyed by Matt here. He successfully brought a defamation action against her on behalf of Ray Andracchiano.
Let me explain it. Here's the best way to pronounce her name. Okay, think of Pinocchio.
Okay,
but instead of Pinocchio, it's Andracchio.
Okay, I always add an Iano because it's like, well, it's already Italian. I got to add more stuff, I guess, like a pizza. But so Andracchio. Okay, gotcha. Yeah, brought on behalf of her in a rather the defamation claim was really horrific. The stuff that Critical K was alleging was pretty gross.
I mean, it was pretty nasty. But what we did that was kind of interesting on our case was, now I don't know. You're in Minnesota, right?
Yeah.
Okay.
Yeah. Unfortunately,
I don't know what your long-arm jurisdiction statute is like. Okay. But I practice in Mississippi and Tennessee, and in Mississippi and Tennessee, our long-arm jurisdiction statutes, you could drive a Mack truck through. Okay. Basically, if you commit a tort in whole or in part in Mississippi, and you've got minimum contacts, come on down. We'll have court in Mississippi.
But she didn't want to, Matt. She was like, "No, I don't want to do that. I don't want to go there."
No, she didn't want to. And so the reason we were able to get personal jurisdiction in Mississippi is when Miss Yax was making her statements. She was making her statements on her YouTube channel, which, if you think of the Crystal Ball case and the other ones, it's like, well, I mean, you're just,
you're in ether.
Yeah. You're at your home and you're not necessarily directing it to this state or that state or whatnot. But on the days and time when she was doing the statements in question, she actually was on the phone interviewing Mississippi people while she was making some of the statements.
I remember this.
So I thought to myself, well, it's no different than if I were to just pick up the phone and call Nick Recato on not even having 70,000 people listening, and just say, "Hey, Nick, Ty Beard, guess what he did yesterday?" I mean, our mutual friend Ty Beard
probably played a board game or two. The weirdo, wrote another Dune review on Facebook.
Yeah, watching old movies with his wife and daughter. So I mean, you get the point. And that would have been under Fifth Circuit precedent enough to trigger personal jurisdiction in Mississippi. And so I figured, well, the only difference here is that you had 10 or 15,000 people listening to it at the same time. So why not?
Right. And well, that's the interesting thing about her case, as opposed to like a general case on YouTube. Sure, you're spewing into the ether, and you may even, depending on where the subject is, you may get a concentration of people who are like looking into that subject. If they're not another internet person, but say they're a person that's important to a location, that's still not reaching into the jurisdiction, though. You're reaching into the forum. You're just still talking to the air. But the moment you pick up a phone and dial in while on there, you're making the statements to someone there. You're calling in intentionally. You know the area code. You know the number you're calling. You're saying, hey, I want to talk to you and interview you and then tell you about this person. Well, those defamatory statements are now being made and targeted at the forum state. And that's a whole world different than what goes on normally. And there are other ways to target the forum state too. I've posited that I guess you could do like targeted advertising for the show, stuff like that. But that'd be a lot harder to prove if you knew, like, if you suspected that was going on, you'd have to somehow prove that they bought targeted advertising and that graphic and stuff like that. But this is a very easy way. We had seen a similar case on the channel a while back. Mark Wade, the comic book author, or the comic book writer, Mark Wade, he had interfered with a contract of a guy named, what was his original? Your boy Zach is how I know him. What was it? It's Richard Myers, his real name. I can't think of what his stupid channel name was anymore. Anyway, he had interfered with the contract from Richard Meyer by calling the company that Richard Meyer was contracting with, which was a Texas company, called up the CEO of Texas on his personal, or the CEO of the Texas company on his personal cell phone. And it's like, well, you're calling the forum, dude, like, and then interfering with a contract that's made in that state. Like, how can you try and claim that you're not under Texas jurisdiction at that point? You
can't. You can't. So we filed a complaint and served it on her. And she, to her credit, she asserted a personal jurisdiction defense, doing it pro se. But I mean, she asserted it and argued it as best she could. But the funniest thing about the whole thing, though, was one of the times in the case, she was trying to argue that due process would not have been served because of the fact that, it would have been too expensive for her to come to Mississippi and come to court. And when she mailed her response, the U.S. District Court down in Jackson, here in Jackson, I guess where I'm at now, took the envelope and put that as part of the docket, right?
Yeah, I
and
remember.
The envelope had a postmark from Hawaii. So I put that in my motion, pointing out to the judge, hey, she's talking poverty, that she can't come to Mississippi, yet she files her motion to dismiss from Honolulu, Hawaii. You know what I mean?
Right.
Now, in fairness to her, I mean, it might have been a vacation that mama or grandmama or somebody paid. I mean, look, we've all had people do that, take us on trips or something. But at the end of the day, if mama or grandmama or somebody can take you on a trip down to Hawaii, mama or grandmama or somebody can loan you the money to get on a plane and fly to Mississippi and come to court. You know what I mean? So
yeah, it's this whole concept about jurisdiction, personal jurisdiction in defamation cases over the internet is hit home recently, as I am being sued, of course. But it's kind of a weird thing, and I don't know that the law is. I always say the law is like 20 years behind technology. I don't think that the jurisdictional arguments are actually prepared for the realities of this. So, like in my case, I made the statements not knowing at all like where the person was. Like, I didn't know where this weird Montegraph guy was. I just know he's a creepy weirdo. I figured he's in some TJ Maxx dressing room or something, and and so he sued here in my local state court, in my county district court, and he sued me here. And my lawyer, I hired Randazza to handle it, and he's saying, well, sure, you can sue me here because you can assert jurisdiction easily, but the choice of law or the conflict of laws favors the Colorado law because they have an anti-SLAPP. It produces a different outcome, and the anti-SLAPP is actually supposed to apply to him because that's his forum, and he doesn't get to forum shop away from anti-SLAPP just because I'm in Minnesota and they happen to be able to assert jurisdiction over me. That doesn't mean that Minnesota law applies necessarily. And so defamation is one of those weird ones where it's a common law claim and the defamation analysis is pretty standard across the board. So you don't really think conflict of laws until you think, well, anti-SLAPP is injected into it. And now we have different questions. And so like in your case, luckily, like she reached into the forum so you could actually drag her there. Otherwise, like if she hadn't done that, you'd have to try and sue her in her area probably to get jurisdiction. But then you have to question whether you have a conflict of laws there, which I had never considered in defamation, the conflict of law part. That was crazy to me. So,
well, you know what? I've got a case right now involving conflicts of laws involving two YouTubers.
Ooh.
I've got I don't know if you know of a fella named Upchurch, right? Are you familiar with him?
No, I think someone had sent me maybe a filing or something from this case. Maybe, I don't know, or maybe you told me about it at some point. It's been a while.
Well, basically, this case stems from, and it's an active case, so I don't need to get into too much detail, but the basic gist of it is that it's centered around the Keely Rodney missing girl situation, and you had two YouTubers making comments about it, but this particular one in Nashville, the Upchurch one, made some statements about my client from Florida that my client from Florida took exception to, and
as one might.
Yes, and so we file a defamation action in the Middle District of Tennessee, where this particular gentleman happens to live and reside, the defendant. But in that particular case, and I bring that all up to say, there's a question about choice of law. Now, you mentioned in the context of anti-SLAPP, but this is very interesting. If you go all the way over to, say, I believe the Ninth Circuit, they have held that anti-SLAPP statutes can be borrowed into federal court. Okay,
right.
But the position in the Sixth Circuit, or certainly the position in the Middle District of Tennessee, is that the Tennessee anti-SLAPP statute can't be borrowed into federal court.
Right. Same with Fifth Circuit won't let you bring any anti-SLAPPs into federal court. Any of the Fifth Circuit anti-SLAPPs anyway. But yeah.
So in that particular situation, the lawsuit was filed in federal court, and you don't have to worry about the anti-SLAPP. Now, we still have run-of-the-mill choice of law situations, and whether or not, in this case, the home state of my client is used versus, Tennessee, and that's presently pending before the federal judge on our motion to dismiss that the defendants filed. So we're going to wait on what the judge says on that. But I know exactly what you're talking about in the context of choice of law. I mean, I've studied probably more about choice of law in the last year and a half, rather in the last year, than I probably had in 16 years of practicing law prior to that,
Yeah, it's not something that comes up all the time.
No, it's not. But also, one of the things that when I was on the show with you the last time, 2 or 3 years ago, I was preparing for a lawsuit against President Biden on the vaccines. But we were kind of worried that we might say something too much, and next thing you know, the boys from YouTube might bring you down.
Oh, and man. They never did that. That's being scrubbed from everyone's memory. No. Why would anyone do that?
So I was very discreet in not mentioning that in any of the panels, but that was something we did. We had a case that I represented 5 employees at a local university, and we sued President Biden and all the relevant people that we could think of. And it just so happened we filed our lawsuit in federal district court about 10 days before the Mississippi Attorney General joined in with the Louisiana Attorney General and other attorneys general to file their suit. So we actually got on the docket before they did. Now, they filed in different states. I think they filed don't know if it was in Kansas or in Louisiana where they filed. I can't remember, or Missouri. But anyway, we filed ours in the Northern District of Mississippi. And my theory on the case was not a bodily integrity, 14th Amendment approach to things. I wasn't thinking about that.
That doesn't work in anything other than, well, it used to work for abortions, but that was it. It's literally the only thing that body integrity works for under the 14th Amendment that I'm aware of. Right.
And that was around the time Dobbs either was about to come out. I think it was still in the process of coming out. And I had, just to back up a little bit, I got admitted to the U.S. Supreme Court working on one case I had in Mississippi where a woman was just brutally abused. And I don't want to go into too much detail here, but brutally abused because her husband had been let out of jail on a prison furlough, or not a prison furlough, but a jail furlough, a county jail furlough.
Right.
And she just got tortured. And we filed a federal lawsuit against the county citing the state-created danger doctrine. And just so happened that every other circuit in the country has adopted that state-created danger doctrine except for the Fifth Circuit. Sure. Hello. So we lost on a motion for judgment on the pleadings in district court, and then we appealed to the Fifth Circuit. Fifth Circuit, God bless the judges down there. They were very sympathetic for my client. But they says, listen, Mr. Wilson, we're not going to change our rules for this case. We stand by what we say. And so a firm in Washington took the case and appealed for cert. And in the process, they were kind enough to sponsor my admission since I brought the case up to them and everything. Well, anyway, right. When the Supreme Court decided not to take that case on cert in February of 21, and it was a real heavy 14th Amendment substantive due process kind of case, something told me right then and there that the Dobbs case was going to end abortion, because I knew that they were not trying to muddy the waters with some substantive due process stuff by a case like mine, which would have been a clear slam dunk in that area, to be honest with you. Okay.
Right.
So anyway, fast forward to the Biden lawsuit. I knew that substantive due process wasn't going to work, bodily integrity, and it was going to be very counterintuitive to everything that we were trying to do in Dobbs as a movement. So I looked at it purely from a statutory examination of the Procurement Act that President Biden was using to describe his authority for telling federal contractors that they needed to get this vaccine. And the basis for that was, okay, we're going to save a whole bunch of money for the government because we're not going to have to pay for sick people to have COVID. So therefore, I'm going to make you take this vaccine. Okay, that was the whole basis.
Yeah, so I just not to interrupt too much. My buddy Phil Labonte, he just posted this clip. He was making fun of Destiny.
Yeah.
Because Destiny was on like Piers Morgan arguing that no one ever said that the vaccine was going to like stop COVID completely or that you would not transmit it. And then he just had this giant montage of people saying, like Bill Gates and Fauci and Biden and all of them saying, oh yeah, if you get the vaccine, you're going to stop the transmission dead in its tracks. Like you won't be passing it on. It's like, no, they all said this stuff. It's crazy what they were doing with that. But yeah, sorry, that just triggered me because
what I decided to do was to argue it on a purely economic standpoint, to say that the president exceeded his authority under the Procurement Act. So we got an expert witness from D.C., from the Heritage Foundation. And if you had asked me 15, 20 minutes ago what her name was, I could have told you, because I just messaged. I saw that she had testified recently in the Senate about, forget what it was. But anyway, one of the sharpest people I've ever been around. And she testified by Zoom and analyzed and says, look, we're actually going to lose more money from people quitting their jobs and not taking the vaccine and all this, that, or the other than the money would have been saved from people who actually missed work because they had COVID.
Right.
And let me tell you what, that hearing was something else, because it was little old me and my clients, and we had like 5 or 6, maybe 7 Justice Department attorneys on the other side. A few of them had flown in from Washington to try to argue this case. And But we ended up losing purely on the question of standing. The
federal standing. I hate it. I hate it. I hate it. I hate it. Sorry, go on.
Well, but no. In fairness, what they were saying was that the executive order had so many exceptions in it, and one of the things that the judge contended was that we had not proven that our university fell into the executive order, and that instead it could have been because we were doing this because of what the state of Mississippi was saying. Well, the thing about it is the state of Mississippi's order mimicked what the federal order was, but literally said if the federal order is ever shot down or found unconstitutional or ends, this will end. In other words, it was clear that the only reason the state of Mississippi was doing this was because the federal government was making them do it. So we figured that was going to be enough to justify standing, but the judge disagreed, and so we appealed to the Fifth Circuit. But before we could get to the Fifth Circuit and actually have any arguments on the matter, the president rescinded the executive order, and there you have it. It was all moot. But it was an interesting experience. So we worked on that, and I've had, like I said, I've had some interesting cases in the last 2 or 3 years.
You're like busy and stuff. That's ridiculous. You should stop that. You should just not like don't like try to change the world and do law and stuff. Like don't help people. That's silly.
Well, I mean, right.
Well, speaking of which, you are now engaged in helping as a friend of the court. Someone in dire need of support, of your support. It's beautiful support. You've written an amicus brief.
By the way, that was a very good Donald Trump impersonation. I really like that, Nick.
Thanks. It's one where it doesn't sound like him at all, but it sounds like exactly like you remember him sounding.
Yeah.
Which is that's to me, that's like if you sound like the person exactly, that's not a good impression because that's just like too eerie. But if you sound like you're like, oh yeah, that is how they sound, and then you hear them and you're like, that's not how they sound at all, actually.
Kind of like Bill Clinton, like I want you to know I feel your pain.
And your mom and your sister probably too.
Or well, I'm Ronald Reagan. Hello there. I mean, you get my point. Exactly.
Yeah.
I know what you mean.
Mm-hmm. I would do Obama, but I can't say the N-word that much. Because he raps. He does rap lyrics.
Yeah.
That was the joke. No, so anyway. Sorry. I forgot we're still on YouTube. No, but you've written an amicus brief before the Supreme Court in Trump's immunity case, which is really cool. It's been docketed. It's there. Like they've accepted the amicus brief. It'll allegedly be read by at least a clerk and somewhat considered as they're rendering this decision. So I really I wanted to bring you on. I wanted to talk to you about this immunity case, about kind of what you're thinking about the I guess should a president have some sort of criminal immunity? What should the scope of it be? Like, how far does it go in terms of federalism? What's the root of the immunity? Civil presidential immunity is rooted in the separation of powers. Justice Department or the judiciary branch, not the Justice Department. The judiciary branch says, hey, we don't actually have authority to hold a president accountable for acts as president. We don't have authority over the executive branch. If we did, we could just jail him or fine him or whatever into oblivion. The president wouldn't be able to act. So we don't do that, or not jail him, but you could bring civil suit and just cripple the executive through the judiciary. And that's not what they're set up to do. So it's rooted in separation of powers. So is this thing rooted in separation of powers as well? Or is there some other consideration? Are there federalism concerns? These are the questions I kind of want to get to. I was thinking since, just kind of the nature of our setup here, I'm probably not going to bring up the brief today. I do have it. If we want to pull any specific parts, I can, but I'd rather just kind of talk conceptually about it and maybe go through the brief on Monday on my show and read through it. But there's a whole lot going on with presidential immunity, and Donald Trump is the focus point of it because there are several criminal cases against him. From different jurisdictions over different matters, covering different potential acts, which may be quote unquote official, which may be quote unquote personal, which may be campaign related. At least these are some of the theories that have been pushed forward in court, usually by the prosecution. So I wanted to talk to you about it. tell us about what's in your brief and where you go with it.
Mhm.
And then after that, we're going to talk about one of those criminal cases, which is Fani Willis and
Yeah,
Nathan
yeah.
Wade. So, but let's start talking about this brief. Can you
Mhm.
summarize kind of
Sure,
your
sure.
position, or how do you want to start with this?
Well, let me tell you why I got the idea to even do this. So, I was listening to another one of the shows in the afternoon. I won't name the name of who the person is because he may be a friend of yours. He may be somebody who you despise and hate with a passion. I don't know.
Yes. Those are both true. Who is it? Come on, name him.
I was listening to, no, seriously, I was listening to Robert Gouvea's program in the afternoon.
That guy's awesome. No, I like him
He
a
is,
lot.
he is. But I hadn't mentioned his name to you before the show, and I don't want to go on someone else's show and plug someone else. You know what I'm getting at. I mean, I just didn't want to.
Here's all good. You don't ever have to worry about that. But no, I love that guy. He's awesome.
He is. I love his show, and I've gotten to the habit the last couple of weeks with the Fani Willis story, just listening to him every day. But I was listening to him, and he was reading on February 28th or the 1st of March the order of the court saying that the deadlines for amicus briefs or whatever, and something just jumped out at me when it was the amicus brief. It was like, now let me explain this to you. First of all, I'm a Christian, and I have a very, how do you put it? My faith is a very big, important role in my life.
Right. It's critical to who you are.
It is. And I'm not saying that to like pat myself on the back or anything like that, but I'm just trying to give you an insight of where I'm at. And sometimes when I get these thoughts or hit me, I mean, I really believe it's like, maybe the Lord is just prompting me to do something. Okay. You just do it if you believe it's what it is. And so I got the bug to do that. Mentioned it to a couple of friends of mine, and they seemed amenable. That's not a bad idea for you to do that. And my wife was supportive of it. I mean, so long as it didn't bankrupt us, or I didn't, spend so much time on that I couldn't do all my other duties. But I mean, first things first and everything. But I was just, for the first 3 or 4 days there, just driven on trying to write something, and I wanted to do something that, because you don't want to just write something that repeats and rehashes what everyone else is saying,
right?
Because they don't like that. It's wasting their time. It's wasting your money. It's it's not worth it. And so I wanted to give a different approach and a different viewpoint. And the main viewpoint that I have, I think that's a little bit different than others, is that I believe that presidential immunity should extend to a president who is acting in good faith. And I'll go a step further, that a subsequent president should not be able to prosecute a previous president if the subsequent president is acting in bad faith, because it all flows from the obligation to faithfully execute the laws of the United States. Okay,
sure.
So
that's that's the faithfully execute clause from Article 2 of the Constitution. That is the duty of the executive branch, is to faithfully execute the laws. That's their whole purpose.
Now, along those lines, you mentioned the executive branch, and this is something that, it's a very relatively new constitutional doctrine of sorts. I mean, I think Justice Scalia was one of the first people in the late 70s, the 80s and the 90s to really touch on the fact that of the unitary executive, meaning the president is the executive branch and all the other people under him are not really part of the executive branch. They're just his agents. Okay.
Right.
And that flows from Article 2, Section 2, which says that the executive power shall be vested in a president of the United States. Definite article, or you get what I'm saying. And
right. And it's real quick. I love this line because it's so important to compare the first line of Article 2 to the first line of Article 1, which is the legislative power as defined herein shall be vested in a House of Representatives or in a legislature comprised of the House of Representatives and the Senate, which is way different because the executive power is a power that is understood in 1791. It's understood that the common person reads this and they go, oh, the executive power, that's the king. Like that's my basic concept is
Mhm.
this is a king, this is a monarch, this is a ruler. This is what the entire world is experiencing right now. The legislative power as defined herein was a new creation of the United States. I mean, there had been other sort of legislative bodies that had existed throughout history. Obviously, you can go back to Greece, you can go back to Rome, you can find these things, but you don't get this one. And what it does is specifically take these people as they define them, and then it constrains the executive branch. It says, no, these are executive powers actually that the legislature holds typically, and we're going to give them to these guys instead. So the executive power is here, but the legislative power is here, and they take away the lawmaking authority of the executive, and they leave just this law executing authority to him. But I find it wonderful because, especially in this topic, people go, well, no one's above the law, no one this, no one that, no one this. And you go, wait, if you take an originalist approach to this and you go, the executive authority, the executive power being vested in a president, I mean, that's a king. And while they're not above the law, the king wasn't above the law. The king was... I like how you say he's also not below the law. President's not below the law either. But the law doesn't apply the same to the king. And in the same way, it doesn't apply the same to the president. People tend to be like appalled or shocked by that. And we go, well, it doesn't apply the same to Congress. It doesn't apply the same to any state actor. Qualified immunity exists. Like you and I don't get deference on our choices and say, well, it's part of your job, so you don't go to prison. It's like, whoa, wait a minute. Like, no one else gets that. The law is not evenly applied to so many people in positions in the United States, but we act like it is just when the president's concerned because it's convenient to say, well, no one's above the law.
Well, I mean, going a step further is that I think President Nixon, God bless him, his whole approach to letting a special prosecutor be appointed, and I mean, if he had the idea of the unitary executive in 1972, 73, he would have just said, forget this. I don't need to ask the CIA to go tell the FBI to stop investigating this. I'll just pick up the phone and call the FBI and tell them stop investigating this. Now, that would have been, now let me qualify that and say that would have been an abuse of power. That would have been probably and certainly an act by him to not faithfully execute the laws. But I don't think you could arguably say that was an obstruction of justice when the FBI is actually his agent. In other words,
I think you could arguably say, we haven't tested this, but arguably say that's part of the presidential pardon power.
It is. Well, true. That's true. That's right. Because if you're telling somebody not to investigate someone or not to prosecute someone, that's no different than if he just did a blanket pardon of that person right then and there. If he had in June the 18th of 1972 decided, okay, you see these 5 guys that broke into the Watergate, to the extent they violated any federal laws, they are hereby pardoned. Now, I mean, that would have been plenary power. You couldn't. Now, there would have been a lot of the impeachment.
That's your solution. You got impeachment.
That's right. But anyway, so to say that you've got a special counsel working for the attorney general who can investigate the president. Let's just use President Biden, for example, here, because he's now the president. To say that you can investigate the president and prosecute the president for crimes using the power that the president has as an executive, I mean, it would be no different than the president prosecuting himself.
Right.
And you can't do that. And so the only mechanism to give account to the president is by way of impeachment and by way of removal in the Senate, because that's your only oversight for the president. Now, it's interesting because this is in tension with the law against the provision against bills of attainder. I mean, in other words, if Congress right now,
made it illegal to have Matt Wilson on a stream tomorrow, they make a law that says if you have Matt Wilson on a stream, you're going to prison. They can't apply that retroactively to me as a criminal statute.
But not only that, they couldn't single you out, period, as a person, because it would be a bill of attainder. That's why statutes, for example, like maybe this, I haven't read the bill, but let's use this TikTok bill, for example.
Yeah.
You're not going to have a statute that says we are banning TikTok, period. Okay. You're going to have a statute that describes actions that might fit TikTok and other similarly situated people and say those actions you can no longer do going forward. Okay.
Right. They do
but-
they do that in the bill, but the funny thing is they had examples, TikTok and ByteDance.
Yeah, I see what you mean.
Here you go. These are in there just so we're clear. It is you too that we're worried about, but also everybody else who's just like you.
But so it seems to me like you've got that general rule that says bills of attainder is wrong, but you have this very specific exception that says we can impeach you and we can remove you from office and we can sentence you to never be able to serve in public life ever again.
Right.
Okay. All right. So you've got a case where the specific is placing a limitation on the general. Okay. And
now,
so
I have a follow-up question for what you just said when you get to your next stopping point. I just wanted to say it so I remember.
So, in that context, you've got the president who is the big cheese, the enchilada, the chief enchilada. He is the one who has the authority to enforce the law. And the only people that can enforce the law on him essentially is Congress. So when you have subordinates who try to say, we are now going to be independent from the president and we're going to investigate the president or investigate his interests, then what you're essentially saying is that these people now are superior to the president. And therefore, if they're superior to the president, they're acting ultra vires because they are not operating under the authority of the president anymore if they're trying to usurp that authority to say, okay, now, Mr. President, you have to be given account here. And that's, I think the whole special counsel stuff in the 70s with Nixon turned that on upside down. And
well, it puts them literally above the law.
Mm-hmm. It does. Now, what was the thing you were thinking of?
Okay, so flowing from that statement about impeachment, you said obviously the House has plenary authority to bring impeachment articles. Mm-hmm. The Senate has plenary authority to try an impeachment. If they do successfully convict on impeachment, they have a subsequent question, which is, do they prevent the holding of public office permanently after that impeachment?
Yeah.
Right? Mm-hmm. Now, what's interesting is another part of the impeachment, I guess the impeachment phrasing clause is that an impeachment shall not be a criminal conviction. However, an impeachment, a criminal conviction can still flow following impeachment. Mm-hmm. Mm-hmm. So my question to you, I've seen this asserted, and I was just curious to your opinion. The assertion is that because that phrasing exists in the clause, does that automatically then imply that a president is immune from criminal conviction until an impeachment has occurred? And only then he would lose his immunity at that point. That following an impeachment, something that the president may not be criminally liable for, he would be potentially criminally liable for afterwards. What do you think about that?
Well, there's two schools of thought. Okay, there's the school of thought of the D.C. Circuit that basically says that no, that was not a limitation. It was basically put in place there to say that just because a president has been impeached and he's been convicted does not mean double jeopardy is attached, and therefore that the now former president could not be charged under a res judicata type double jeopardy bar. Okay.
Right.
Now that he's been convicted, you can go ahead and sue him. The other school of thought is that is a prerequisite. Now, first, let's examine this under the rubric of a sitting president, like with President Biden. Obviously, the executive branch cannot prosecute itself any more than a judge could sit and decide his own divorce. Okay?
Real quick, FDR is the greatest sitting president.
Oh gosh, Nick, that was.
Sorry.
Oh my goodness. I mean, I'm going to get in trouble just from laughing at you. I don't write the jokes. It's late at night.
Jokes.
I'm just laughing at them. Anyway, so the question is, could you go after a former president under the same rubric? Now, let me explain this concern. In general, I would say you still have to impeach and remove first, but I'm going to throw out a hypothetical that has given me a little bit of pause. Okay. And think of this in terms of a bill of attainder and juxtapose that in this context. Let's imagine that it's January 19th of whatever the last year of a president's term is, okay? Whether it's Biden, whether it's the next person, whether it's Trump too, whatever, okay? Sure. And for whatever reason, that particular president decides, I'm sick and tired of Justin Trudeau. We're going to just drop a bomb on Parliament Hill and Ottawa and, blame Canada for everything, okay?
Oh, that guy has my vote.
Well, imagine that happened, okay? All right. Well, it's not like Congress could immediately come and impeach him, right?
Right.
Because, how are you going to impeach somebody? It just takes time. So now we've set the precedent that the Senate can have a trial after somebody's left office, but the question I have is, could a House of Representatives impeach a former president for stuff that was done while he was president and it not be a bill of attainder? You see what I'm getting at?
Yes. Right.
And going back to what I was saying about how impeachment is a specific exception to the general rule against bills of attainder, I think you probably could, but just in case I'm wrong, you could theoretically leave the door open for a subsequent prosecution of a president. But then again, even then, though, that goes back to the overall reaching issue of good faith. I mean, if a President Biden decided that he was going to bomb Ottawa and blow, Parliament Hill off the map, could you honestly say he was doing that in good faith? Probably not. Okay. But I think the safer bet is still to say that an impeachment could still be done by the House even after a president left office, and it not be any more of a bill of attainder than if he were in office.
Right.
You see what I mean?
No, I agree. Yeah, and this is one of the interesting things. Donald Trump has done so many amazing firsts that he never tried to do. He was the first time a president has been impeached twice, which is great. I have a question for you, though, Matt.
Mm-hmm. What's that?
Has Trump actually been tried for his second impeachment?
Well, there was a trial after he left office.
There was. Now, the interesting conundrum they have is he was impeached while in office. They worked really hard to get that done. It was like the last day or the day before the last day. They wanted to levy impeachment charges against him, or levy the impeachment against him. But the Senate, of course, would take time to actually hold the trial. Now, they held the trial in front of the full Senate, which is not required for anyone except a president.
That's right.
However, Chief Justice John Roberts did not sit for that impeachment trial. And the Constitution says that the Chief Justice will preside over the impeachment of a president. So we have this weird thing. He's impeached as president. He leaves office and is technically no longer president. He's tried by the full Senate, which would be for a president, but he's tried without the Chief Justice, which would be a constitutional requirement for trying the president. I'm not so sure his second impeachment trial actually occurred.
I see what you're coming at. I see where you're coming from.
And this goes to this question that you're talking about, because what do we do? Like, I know they wanted to avoid the legal quandary of impeaching him after he left office. Because we don't know. We don't know if you can impeach someone after they leave office. But in the case of a president, it might be necessary, especially if we're talking about piercing immunity. And there is still there's a non-moot question. Leaving office only moots the first question, which is, can they be? Do they need to be removed? But the second question is not mooted, and that is, can they hold further public office? And it's not just can they become president again; can they hold any office of trust under the United States? Or anything. So it's still the impeachment is still ripe. So they impeached him as president. Tried him they said, well, he's not president anymore, so we don't need the Chief Justice. The president pro tempore presides. But this isn't settled law. Like, no one knows what happened here. And I'm actually really curious about this, because I think it would be interesting as a legal exercise. Let's say Trump wins and then let's say the Democrats take a significant lead in the Senate in 2024, and they bring the impeachment trial of Donald Trump for the second impeachment, claiming that the initial impeachment trial for his January 6th actions is actually invalid, as it was not presided over by the Chief Justice and he was a president. So it.
Well,
what
then
would,
you
what
might
would happen
also,
there?
well, in a case like that, though, I think you would probably have an estoppel defense of some sort. I mean, even if you don't have assuming simply for the sake of argument that was an invalid impeachment trial, okay?
Right.
I think under the rules of equity and you've judicial estoppel, collateral estoppel, I think they would be hard pressed to try to bring that up again, given the fact that it was the Senate's own negligence in not bringing the Chief Justice in to hear it.
They tried. He refused.
Well, even so, the point being is that if the Chief Justice has refused to come do it, then it stands to reason that I kind of see where you're coming from. I mean, it's
an interesting question, because is John Roberts saying this is not a valid impeachment? Is he saying that you must impeach a president while he sits? Maybe that's what he was saying, or was he suggesting something else with it? Was he suggesting that Donald Trump is not to be like someone who is impeached as president would then be tried as a non-president if they lead off? Maybe that's what he said, but he did it without comment. So we have no idea. And this one gets to me because just again, related to what you're talking about here is, and this came up in my debate with Destiny about Trump's actions. It's like, I was like, well, you impeach him. He's like, wait, so you impeach him after he's out of office? I'm like, well, why not? Like, why can't the House bring, like, let's say, someone found out that Biden did some that Obama did some crazy thing, like crazier than anything we know about. I don't even know. Like maybe he gave cocaine to Hunter Biden. Maybe that's what he did. So we find out that Obama does this, and they decide, well, we're going to go back and impeach him and prevent him from holding further office in the United States. Can they do that? Can they impeach Obama and then go after him that way? I don't know.
Well, let me tell you, one thing that comes to mind, though, is that you can only be impeached and removed for office for high crimes and misdemeanors. Okay, bribery, treason, or other high crimes and misdemeanors. Okay,
right, but like high crimes and misdemeanors doesn't mean anything.
Well, no, but follow me though. It's still like crime or a misdemeanor. Okay, and usually under federal law, you have statutes of limitations for most crimes. Okay. I think the standard default statute of limitations is 5 years in federal court. I mean, it varies from crime to crime, but I think the default one is 5 years for most everything. Correct me if I'm wrong. Anybody who knows better than me on that.
No, I think that's a typical one. Unless you've got we've got some new statutes of limitations where we've got, of course, in murder charges, you have unlimited statute of limitations.
Exactly.
And now, this one might apply to Biden. You've got, like, if you criminal sexual conduct, like if he's sniffing too many children too closely, for example, like they could bring those. Some states have implemented like a 30-year statute of limitations, or the statute doesn't kick in until they're the age of majority. Those types of things.
But I would think you would have two constitutional defenses that. Well, maybe one of them would be statutory, the other one would be constitutional. The statutory defense would be that if the underlying high crime or misdemeanor that you're being charged for has a parallel statute of limitations in the U.S. Code, then that particular president couldn't be charged with that crime. For example,
Sure.
President Carter, God bless him, is not going to be charged with anything because he's not in the best of health, as we all know.
He's still alive? I thought he died like a couple months ago.
No, he's still alive.
Oh my God. Poor guy.
Yeah. In fact, I have to tell you while it's a sidetrack. So we live in Mississippi, and we were driving to Orlando for Disney World back in September. And as we were driving, I noticed that we were about 20, 30 miles from Plains, Georgia. So my wife and I had been through there once before. Have you ever been to Plains, Georgia?
No.
Okay. Plains, Georgia is one of the smallest towns I have ever been to in my entire life. And I'm from Mississippi, where there are small towns, okay?
Mm-hmm.
All right. This town has a train depot, an old school, a few buildings on the street. And then on the highway, you've got a fortress, which is President Carter's home. Okay. I mean, really.
Cool. Yeah.
And so we were driving through, and we told my son that, wake up, son, we're going to be going through Plains, Georgia, to President Carter's home. And of course, he's thinking like Boyhood home or something like that. And we're driving past the actual house where the president is inside the house. And my son is always like afraid the Secret Service snipers are going to come and get us or something,
Yeah, me too.
But anyway, I digress. So, but if there was a situation where somebody found out that, God bless him, President Carter had committed some crazy crime or something like that, he left office 40 years ago. So whatever he committed would have been barred by any statute of limitations anyway under normal circumstances, unless it was one of those types of statutes like you're talking about a murder or something. Okay.
Right. Yeah.
Now,
Obama did drone strike a 16-year-old American citizen.
Yeah, but the only problem is most murder statutes, though, are state law and not federal.
Oh, but this one would have been federal because it was in Yemen. However, it was executed, I believe, technically from U.S. soil, since the drone pilot that was acting as the agent of the murder would have been on U.S. soil at the time from a military base, presumably. I guess it could have been a mobile operation. I'm not quite sure where the drone was piloted from, but you can make the argument that Obama reached from U.S. soil, a U.S. military base in near Yemen, and used a drone piloted to fire across international lines to murder.
That's almost like my hypothetical about bombing Parliament Hill in Ottawa or something. I get what you're saying.
Oh, I didn't want that. No, I'm just kidding. That's a joke. I won't finish the joke.
But the constitutional argument I was going to have, though, is the fact that we are all entitled to speedy trials. Okay, let me tell you about my very, very, very first felony case ever as an attorney. Okay, this is going to crack you up, Nick. I don't think I've ever told you the story.
No.
So I was a Mississippi attorney at the time, but I was not yet a Tennessee attorney because I was about to take the Tennessee bar. I'd only been practicing law for about 2-3 years. And I was changing jobs. In fact, my wife and son, and was my daughter born yet? Yeah, she was born. We were about to move back to Starkville, Mississippi, from the town we were living in at the time. And but my old boss from the place that I was leaving had needed for me to handle a criminal matter for him. And in this particular criminal case, the young man in question had been in Mississippi. He was an Alabama kid, and in the year 2000, he had gone to a party, and there was at a hotel, and there was a raid of some sort, and contraband, illegal things were there, and the guy got detained and he got arrested. But they asked him to be a narc, and they were going to ask him to help out and that kind of stuff, and he agreed, and they let him go. They let him go on his own recognizance. Well, in 2001, they go ahead and charge him in absentia, get a bench warrant on him, but they never upload it into NCIC until like 2007.
Oh.
And then like in 2008, he's just running around minding his own business. And I think somebody
he's been a fugitive for 8 years.
Yeah. And so they have to extradite him to Mississippi to stand trial. And so he hires my boss at the time to represent him. And my boss needed me to cover on a hearing. And I'm thinking, speedy trial, the fact, whatever, because a constitutional issue. So I moved to dismiss the case for failure to prosecute, and the constitutional issue I'm telling you about. Well, the assistant district attorney that I was dealing with was I got to be nice. I'm a substitute Sunday school teacher, so I can't really say what I really think. But he was not a very nice guy.
Sure.
And he booked our pretrial motion, because, and this kind of goes back a little bit to the Fani Willis kind of situation with the judge. a lot of folks don't realize how much a judge's docket is really controlled by the prosecutors, if you want to get right down to it.
Right.
Okay. And so this guy set my pretrial motion on a Monday and set the trial on a Friday. Okay. Well, the problem for me personally was the Saturday before the Monday, I was moving my family from Corinth, Mississippi down to Starkville.
Sure.
But to make it even worse, the Wednesday and the Thursday in between the two dates was the Tennessee bar exam. So I had to go to this hearing for this motion to dismiss and whether I was going to actually take the Tennessee bar exam or have to sit and prepare for my first jury trial was going to determine on whether or not I could convince a judge that his rights to a speedy trial had been violated.
Right.
And because the problem was I couldn't go and ask the court for an extension of time and a new trial date without waiving my speedy trial argument.
Yep. You got to take it. You got to take
so
what you got.
I had to take it. So we went in there and praise the Lord, we convinced the judge that this was a violation of his constitutional rights, and that was a dismissal with prejudice, and the kid was spared. And he was just screaming and hollering outside, you're a blankety blank Perry Mason. I mean, he was just so excited. I mean, for those of you kids at home who are not as old as we are, Perry Mason was a very, very famous TV attorney in the 50s and actually movies in the 30s, to be honest. I digress. So anyway, I was able to take the Tennessee bar and I didn't have to worry about going to that jury trial. But I said all that to say in the context of this, if you wait too long to bring a charge against somebody, that does have a violative impact on due process. And I would say that would apply even in the context of presidents. So let's use this hypothetical about, okay, well, we impeached him in 2020, but our trial was an invalid trial, but we're going to go ahead and do it again in the Senate in 2025 or something like that. I would tend to think that you would have some serious estoppel issues there, due process issues. But the problem is,
I have a couple objections to what you're saying.
Yeah.
Because I like this discussion. My first one is it's express in the Constitution that that the impeachment process is a non-criminal proceeding, and it's not really a civil matter, and it's not handled by the judiciary. So I don't know that statutes of limitations apply or could be applied in it. And I really wonder, like, taking the hypothetical in a different way.
Yeah.
Let's say I murder someone when I'm 20.
Okay.
And then let's say I'm never prosecuted. No, nothing comes up. DNA evidence shows that I'm this murderer when I'm 62 and elected president of the United States. Do they then, no, that would be a bad one because it's murder. But let's say some lesser thing, maybe a manslaughter, criminal vehicular homicide, something where it's bad, right? Like I did it. We are past the statute of limitations. It was obfuscated from the public, but now it's shown that I did this. And can they go back and impeach? I don't like that's an interesting thing. My understanding of impeachment is, while it says high crimes and misdemeanors, since there's no actual definition of high crimes and misdemeanors that's contemporary to the writing, they've always just taken it as basically political, whatever you can sustain. And the reason it's political and whatever you can sustain is because the House has plenary authority to bring it. The Senate has plenary authority to try it and convict. So there isn't like judicial review of impeachment. There's not the judiciary doesn't have the power to review. The only power that the judiciary has in any capacity in impeachment is that the Supreme Court Chief Justice presides over the proceeding, but that's it. Like he doesn't, so he would handle objections.
And to take it a step further, I'll take your argument and go one further. Let's go back to the days of Bill Clinton, when the independent counsel, and by the way, we're going to interchange and use different terms, folks. When we're talking about that, the Iran-Contra affair with President Reagan, and we're talking about Monica Lewinsky or the Watergate affair with Mr. Clinton, we're going to use the term independent counsel because that was a special office created by statute in the late 1970s, but it expired by law in 1999. Okay. But anything involving President Nixon or going presently to President Biden or President Trump, we would be using the term special counsel because that is a completely different animal. Okay. Right. But anyway, the independent counsel, the original independent counsel, wasn't Mr. Starr, but it was a different one. He was appointed to investigate the Whitewater financial affair with the banks and the savings and loan and the McDougalls and that kind of stuff. And that predated Clinton's presidency. So in that sense, I guess, if there had been no Monica Lewinsky, if there had been no
I had a Monica Lewinsky joke, and I'm just not going to say it. I'm not going to say it.
Again, I'm a substitute Sunday school teacher, so I got to be careful. I'm
going to hashtag respect that.
If all there had been was evidence of wrongdoing with respect to how President Clinton, as governor of Arkansas, had handled various aspects of savings and loan regulation and that kind of stuff in the early 90s and the late 80s. If there had been an impeachment and a removal based on that, then that would have had nothing to do with his presidency. It would just had been something to do with his character. But even then, and I was by no means a fan of Clinton. I mean, I tell you what, after practicing law for 17 years, I've learned to be a lot more gracious for people. You know what I'm saying? But
yeah, it does kind of, it gives you a little bit of a different perspective.
Yeah.
You're like, maybe there's more to the story.
But back then, I mean, I was, if the Matt Wilson of 1995 were to meet the Matt Wilson of 2024, he would probably give me a lot of what for about, how I am right now. But back then, I was just a rabid anti-Bill Clinton kind of guy. But even then, as a rabid anti-Bill Clinton kind of guy, I couldn't wrap my head around the fact that they were even investigating him under the auspices of impeachment and removal, for something that might have happened when he was governor of Arkansas. Do you know what I'm saying?
Right. Yeah.
Okay. So that I see where you're coming from, and it is kind of murky, but I'm of the persuasion that if we're dealing with something that situates around the universe of separation of powers, and the only place in the Constitution that says who places accountability toward the president or the president it must be accountable to is Congress and not the courts, because the courts can't impeach a person. Okay.
Right.
And aside from the fact that the Chief Justice is the presiding officer of an impeachment. By the way, here's a question. The Constitution only speaks of the Chief Justice presiding over the impeachment trial of the president.
Correct.
But what if Kamala Harris were impeached? Who would be presiding over the Senate at that point? She couldn't necessarily preside over it herself.
Because she's the president pro tempore of the Senate. So, how would she preside?
Well, no, she's not the president pro tempore. She is the president of the Senate. You're right.
Right. So, President pro temp would have to do it. Or, I guess, they could request the Chief Justice. Right? Like, you could... Yeah. The Chief Justice shall preside over the president, but that doesn't preclude him from presiding over another impeachment, I would think.
Yeah.
But I don't know. That's why I've loved the end of Trump's term so much, is because all of this law that is all sitting there, and every talking head on major media, all the legal experts and analysts and stuff, they'll come out there and make these statements about what's going on and what should happen. I'm like, you have no idea. Like, no. You have none. Nobody can know. We can all take guesses and we can make our arguments. But what we're going to end up doing is most of these questions are going to have to be answered by agreement or by the Supreme Court coming in and everybody going, yeah, I guess you guys can answer this question. I guess we'll go along with it too. And we really don't know, but that's all going to be a product of of society and the times and their political considerations.
Yeah.
I mean, we've seen right now, I've been talking about a lot about the run up of the ethics accusations against Clarence Thomas.
Yeah.
And it's like, why are they like, man, they went hard after Clarence Thomas because they want him to step down. They want to justify packing the courts. They want to justify overturning this conservative court in some way as fast as possible. And so what they do is they're trying to raise the political questions, decrease public faith and trust in the courts in some way to justify the next move. And justices do think about that. And whenever anybody challenges that, you just have to point back to FDR telling the court, like, look, if you keep shutting down the New Deal, I'm going to appoint a whole bunch more justices and we're just going to own you. Like, you won't matter. You'll be a footnote in history. And then suddenly all their considerations changed and they started ruling right for him. And it's like, justices are thinking about this and there is political influence. And if we take that and we start answering these questions now in regards to Donald Trump, that's going to affect the outcome. And that's terrifying in one way, but it's also really interesting to me because we don't know where it's going.
Well, the thing is that amazes me is that back when I was in law school, now I went to a very conservative Christian law school. I went to Regent University, Pat Robertson's law school in Virginia Beach, where basically if you were a conservative, I mean, you weren't shunned. Okay. It wasn't like,
right.
I mean, let me give you an example. My law school, inside our law school was the office for the ACLJ. And every now and then I'd walk past Jay Sekulow as he's walking in and out of his office. I mean, that's just how conservative my school was. Mm-hmm. But even so, when I was in law school, we learned and heard of the concept of legal realism. And legal realism in its purest sense is that the Constitution is whatever the Supreme Court says it is. Okay.
Right.
Now I don't subscribe to that. I'm not that type of person, but the left was all into legal realism. The Supreme Court says here's Roe versus Wade. The Supreme Court says there's abortion rights in the Constitution. The Supreme Court says this. Well, now the shoe's on the other foot. It's like, get rid of the Supreme Court.
Yeah.
I mean, legal realism only matters when the Supreme Court is left of center. I mean,
my favorite legal realism is Marbury versus Madison.
Oh, and we talk about that in my brief quite a bit.
Oh, yeah. I need to see. I haven't read your brief yet. You sent it to me, and then I had a bunch of stuff that I had to do later.
Well, let me go ahead and give you a synopsis of it. Okay, so basically, the main gist of what I'm trying to say is that number one, the first thing I come out is I get into an analysis of why what my interest is in this. Okay. And my interest in writing this is fairly simple. I see our country is falling apart, being torn apart by the seams, okay? Because you've got a Republican president who's being bombarded by the left in the courts. And if we don't stand up to this right now, what's going to happen is that the tables are going to one day be turned, and the right's going to be going after the next president, and then caught in the middle is going to be everybody, and we're not going to have a country left anymore because we're destroying each other, and we're basically having the lead up to a civil war. The only thing that makes a civil war impractical is that the states are not adjacent to each other or contiguous to each other. I mean, you can't have North Dakota on the same side as Mississippi and have you get my point.
Right. Yeah.
Anyway, so we're in an upheaval right now. And what we've got to do is recognize that this has got to stop. And right now, the special counsel is prosecuting President Trump under the theory of he interfered with the election and he must be punished. But it's a curious byproduct of that is the fact that he's actually interfering with the election by trying to make it impossible for me and for presumably you and maybe a lot of other people who are listening to the show to be able to vote for President Trump. Now, as voters, we don't actually vote for President Trump, but we inform the selection of the presidential electors who do. And my interest in writing this brief is to say, look, I don't want my interest, my say in who is our presidential electors and who they're going to vote for to be diminished in any way because of what Jack Smith and the special counsel's office is trying to do to prosecute and to persecute a man for exercising discretionary authority when he was president in furtherance of his duties. Okay.
Right.
All right. So that's my introduction. And then I get into the actual argument. And my argument starts with what we've already been talking about, how there is only one person in the executive branch. And that one person is right now President Biden. Okay. Now, because he is the executive branch and all executive power flows from him, that means that the special counsel, even though he may be writing the briefs, even though he may be making the arguments, at the end of the day, it's President Biden who's prosecuting President Trump.
Right.
Because only President Biden is the executive branch. Okay?
Yeah. And there's not to sidetrack too much. I just want to mention this because some people have asked me about it, and I may talk about it soon, but there is one of the amicus briefs out there in this case, or in, I don't know if it's in this case or it's somewhere, basically challenging the authority of the special counsel, because
it is in this case. Yeah.
Right. Because
what it is
not an existing state. He's not an existing U.S. attorney. And so in this case, they appointed someone who is not a U.S. attorney who has to be confirmed by the Senate. And they have effectively deputized Jack Smith as a special prosecutor, which is a division of the executive branch, without having him actually approved by the Senate, who would have to approve any addition to the executive branch.
That's exactly right. That was Attorney General Meese's amicus brief following the petition for certiorari, the petition for writ of certiorari.
Right.
And I think that might have been one of the last amicuses that was filed before the Supreme Court ruled on, we're going to go ahead and take this case. But you're right. So that's one thing. But focusing on that for just a moment, President Biden is the one calling the shots.
Right.
Because he's the only one who has the authority to start and stop a prosecution. Now,
yes.
One of the things...
Briefly, the reason I was bringing that up is because it was less about Jack Smith's his authority and more of the fact that the reason that matters is because the president, the executive authority, is used to appoint special counsels.
That's right.
Because it's used to appoint United States attorneys. And the argument would be if you appoint someone outside of that, they're outside of the executive authority and can't do it, which then leads back to all of this being President Biden is the authority, even if it's special counsel who is slightly removed from the U.S. Attorney's Office, they are still acting under executive authority. Sorry.
That's right. That's right. You're exactly right. Now, one of the things that special counsel Smith, Jack, decides to write in one of his earlier briefs, he's pointing out in the case of Nixon versus Fitzgerald. Now, Nixon versus Fitzgerald is a very important case. And in that case, a guy named Fitzgerald got all upset because President Nixon basically made a policy that caused him to lose his job. And it was his position that was an illegal policy. So after Mr. Nixon left office, he decided to sue President Nixon for the loss of money damages and whatnot because he didn't have his job, right? And so the U.S. Supreme Court ruled that presidents have absolute civil immunity in prosecution. But in their making that analysis, and this is a quote that this is something that Jack relies on, is that the Fitzgerald court says that this does not mean that we are saying that presidents are completely immune from everything, because, and then he goes on to say how, if the government is trying to vindicate the public interest through a criminal prosecution, then that might not be, words to that effect, it might not be an exemption, okay? And so Jack has been hanging his hat on that, saying, well, this is a criminal prosecution, so we're exempt, we can go after him. Well, then my theory is this: it's got to vindicate the public interest, okay? And one of the things that Jack mentions in his brief is that he talks about how prosecutors have a rebuttable presumption of acting in good faith, okay? And
oh boy,
I forget exactly what it was. Okay. And I'm pointing out but even in the case that he's describing, it's not the Fitzgerald case, but it's a different case. The name escapes me right now. It's in my brief. The Supreme Court points out, though, that when you have something like selective prosecution, the judiciary can come in and interfere with the exclusive authority of the executive branch to prosecute. So to have selective prosecution, you have to have a differing effect between people, and you also have to have an adverse negative motive, okay, an illegal motive. And I point out that we have a differing effect right now just by how Robert Hur, acting under the authority of President Biden in investigating President Biden, gave him a pass for doing the exact same thing that President Trump did. Okay.
Well, I want to.
But Jack, though,
I actually want to mildly challenge what you just said. President Trump has a different level of potential, and in my opinion, should be non-potential but definite authority over classification of documents than the Vice President Biden would have had.
Exactly right. Because as Vice President, he didn't have the authority to declassify things. Let's think about this for just a minute.
Yeah.
A lot of folks think that the Vice President is a part of the executive branch, but if you think about it, he's not. He's a part of the she's the part of the legislative branch because she's president of the Senate, and she gets to vote as a tiebreaker on legislative matters. The Vice President is a part of the legislative department. Okay,
right? She's not well. Yes, in that capacity only, though. That's the interesting thing. The Vice President is actually vested with zero authority under the executive branch.
Exactly.
And so, yeah, she can be assigned a task by the president in some way, like, oh, head up this committee, but that's not authority. She doesn't have rulemaking authority. She doesn't have executory authority. The only thing that she would have is if Biden were to fall comatose for a little bit, the 25th Amendment could be invoked. She could take over at that point and act as president until he woke up and someone wrote a letter for him to contest it. But yeah,
prior to the 25th Amendment, John Nance Garner back in the 1940s said this job wasn't worth a bottle of warm spit. And Garner, Cactus Jack, had used to be the Speaker of the House, where he had real power. But then he became Vice President, and he was presiding over the Senate, and had no real power. And it was like, I hate this job. And, But at any rate, so you've got a clear differing effect. Okay, so now we've got to ask ourselves, all right, well, what would be the prejudicial motive? Well, let's think about this for a minute. Federal law sets a salary for the president of the United States at $400,000 a year plus an expense account.
Right.
You've got President Trump trying to go after President Biden in an election, and therefore President Biden is trying to defeat him in order to save a $400,000 a year job.
Oh, yeah.
So my theory is that you could arguably say that the executive branch is acting in bad faith to go after Mr. Trump because Mr. Trump is an existential threat to the political power of the executive branch and the ability of the executive branch, Mr. Biden, to continue drawing $400,000 a year. So I think that's a prima facie case of selective prosecution.
Right. Yeah, that's interesting because I hadn't thought of it that way. But yes, the removal of Biden has a direct economic impact. You could say, well, he doesn't need it or whatever, but it's still there. Mm-hmm. And his total compensation package is actually well in excess of that because he'll have a Secret Service detail for life. He'll have, he'll get those things whether or not. So just the immediate salary, I suppose, that he'd lose.
So
yeah, still substantial.
My initial premise is that in that particular circumstance, President Biden is acting in bad faith going after President Trump, and therefore, arguably, he is violating his oath of office by going after President Trump under these circumstances. Okay.
Sure.
All right. Now, this is a unique situation. Okay. I mean, we haven't had the possibility of a former president being reelected since Theodore Roosevelt ran for a third term in 1912, I believe. And then you had, prior to that, you had Grover Cleveland, who actually did do it in what was it, 1892, I believe.
It was a while back. I don't remember.
It was a while back.
I was young.
So if you ever got into a situation, let's say where, well, I don't know, a two-term president is having to prosecute his predecessor who, 5 years earlier had done something, I don't know, like you were talking about, you might not have the same dynamic of, well, this is an existential threat for me because I'm term limited out or whatnot. You get what I'm saying, okay?
Right.
But it goes back to the fact that if we're going to have a political question that deals with whether somebody's acting in good faith or bad faith, whether it's the former president in his behavior, we need to go through the impeachment and removal process. And then by doing that, when the next president is prosecuting the former president, there is that presumption that the next president is acting in good faith because he's following the will of the people expressed by the House and the Senate in the impeachment and removal process. You see what I mean? Okay.
Right.
That's the first thing I mentioned. Now, I also point out that in President Trump's case, in all of the things that he's been charged with, you can make a case that he was acting in good faith. Okay? Now, let's think about this for a minute. Under the law that was in force at the time, well, let me back up. People may not realize this, but there was, you remember the Motor Voter Act that President Clinton signed back in the 90s? The National Voter Registration Act, I believe it's what it's called.
Okay, yeah, I'm familiar. I don't know the details of the act, but yes, I know the National Voter Registration Act. Is that where they were like when you get a driver's license or whatever, you start they start sending out voter registration cards from everywhere now,
in the mail and stuff like that.
Like now it's like if you go to the video, well, you don't go to a video store. Now you go to the grocery store, you get one with your receipts. Like, oh my God, like they want to register you all over the place.
Exactly. Well, one of the things in that statute in the very beginning were some congressional findings, okay? And one of the things it found was that every U.S. citizen has a fundamental right to vote, okay? And then it also says that it is the duty of federal, state, and local governments to protect that right or to advance that right, to promote the right to vote. Okay?
Right.
Well, I found some case law that talked about how voter fraud actually undermines the fundamental right to vote. So think about this for a minute. As president, Mr. Trump had an affirmative duty to promote voting rights. And by reverse implication, that meant he had an affirmative duty to go after election fraud. Okay? You follow me on that? Okay.
Yep.
So any actions that he takes under the auspices of trying to go after election fraud would have been an official act.
Right. Yeah, of course.
Okay. So now let's back up for a minute. Let's assume for a moment that, people have made this case for the last 3-4 years that this was the big lie, that there was no fraud, there was no fraud, there was no fraud. Okay. And I'm not here to litigate that one way or the other, but I am here to say that even if there was fraud, President Trump could not have proved it if he had wanted to. And you know why he couldn't have, Nick?
They wouldn't let him.
Well, yeah, but think about this. Even if the courts were going to let him, when you file a lawsuit in federal court, what typically happens?
Well, you have a 12B6 motion to dismiss.
But wait. Let me back up. Let me back up for a minute. In 2020, the president had 35 days to litigate his claims.
Oh, right,
because of the safe harbor day falling exactly 5 weeks after the election. Okay.
Yeah, it's near impossible.
Right. So I mentioned in my brief that if on a good day, if I were to sue Nick Rakita in federal court because here we are, I'm in Mississippi, you're in Minnesota, you say something outrageous, you hurt my feelings.
He voted for Biden.
you intentionally inflict emotional distress upon me in some way. Okay.
Yeah.
And I go and I want to sue you in federal court. Well, guess what you can do? You have 21 days to file an answer or a motion to dismiss. Well, knowing that I have only 35 days to litigate this, what would you normally do? You would sit on your butt and do nothing until the very last minute and run the clock.
Maybe even ask for a reasonable extension of time.
Exactly. And then let's say that you did file an answer. You would file a 12B6, and that would take forever anyway. Okay. Yep. But even if you didn't even file a 12B6, let's say you just went ahead and filed a straight up answer. Okay. I still could not get discovery from you because we wouldn't be able to do our Rule 26 F scheduling conference or a pretrial discovery, not pretrial, but our discovery conference until weeks after you filed your answer.
And that's not even considering any local rules that the court might have on any local conferencing requirements that the judge might have for that particular court.
Exactly. Now, I understand that, number one, some of these cases were in state court. And I know, like in Mississippi, I don't know about Minnesota, but I know in Mississippi and Tennessee, the moment I file a lawsuit in state court, I can start sending out interrogatories. I can start sending out requests for production. I can start subpoenaing from third parties, whatever. Okay. But those parties who get those discovery requests can raise their own objections. They can raise their own issues. Okay. And when they do that, that's going to delay the time of discovery. So as an attorney, if you give me a case and you present witnesses that come see me and I swear out some affidavits or whatnot, and that's all I have to present to the court, okay?
Yep.
Then I might be even able to do a Rule 65 injunction for temporary restraining order or something. And chances are that's what you would have to do in a case like this, even if you can get around the whole standing issue. But the fact is, all you have are affidavits. That's the only evidence that you're going to be able to present to court anyway at that time, because there's no other way to gather evidence.
Yeah, I was gonna talk about the other problem with any of these federal cases is federal filing requirements that are attacked under 12B6. Is that how do you allege any specific facts about election fraud? When you think about it conceptually, because the nature of our secretive system, you can't track a voting ballot to me, like you can't do it. So how do you allege the fraud with factual specificity to actually overcome a 12B6? It's really,
because
really difficult.
Rule 9 says that fraud has to be stated with specificity. You're exactly right.
Yes, it's like when this is one of the things that bothered me so much about all of the election cases. Everybody's like, well, all these courts examined it and threw it out. It's like, you guys have no idea how far the courts got to observing any sort of substantive claims of any of these things. There wasn't a way to do it. And when, again, hearkening back to my own greatness, I was on debating Destiny, and he's like, no, the courts brought this up. I said, Destiny, like none of the courts examined any of this. It was all thrown out on standing grounds, or it was thrown out on latches. It was thrown out on all of these excuses to all of this stuff. There's no way to bring any of this. And I was like, in Destiny, no one actually knows how to do this. I guarantee you that no one in the country right now can tell you how Trump could have brought an action. If he had video evidence of someone going up to the Dominion machine and hand cranking up 400,000 votes, no one in this country could tell you how to bring that action. What court do you bring it under? It seems like that to me seems like that would be a literal Supreme Court original jurisdiction question.
Exactly.
But
and here's
the one time that happened, Louis Gohmert filed his case in Texas v. Georgia. Donald Trump joined, and the Supreme Court says in a case with a state versus state action joined by the President of the United States as a plaintiff, the Supreme Court says no one in this case has standing.
I know. That's the craziest thing. And this is the thing that really just upsets me, okay? If we have telegraphed to the whole world that if you want to file a lawsuit about election fraud, if you want to stand up and say that there's election fraud, then you as a lawyer are going to risk your law license.
Yep.
And if somebody like Fani Willis gets their way, you're not only going to risk your law license, you're going to risk your freedom. You're going to be branded some sort of conspirator. You're going to be charged with racketeering. all because you're wanting to bring a case up to court. And now lawyers are going to be so scared half to death of doing that. So now, if you're the Chinese, if you're the Russians, hell, if you're even the Canadians, and y'all want to influence the elections, go right ahead, because if you get lucky, you might get away with it. If not, nobody's going to stop you. Nobody's going to challenge you, because it's impossible to challenge it.
Right.
That's the problem.
And
so
no one wants
that's
to talk
why,
about that.
No. And I put that in a footnote in my brief. I expressly say that. But let's go a step further.
Ooh, I like it.
Let's say, you don't have, you can't get anything done in 35 days. What's your next remedy? Well, guess what? Your next remedy is to go to the legislatures, because under Bush versus Gore, they have plenary power to change their votes, period, because they have the right to tell the electors how to vote.
Right.
A lot of folks don't
up until the submission date, which is what, December 19th or 9th or something?
Well, something like that. But we'll get to the submission dates and that kind of stuff in the next part of my brief. Just follow me on this, though. But literally and purely here, prior to, I'd say about 1800, maybe 1805, 1804, somewhere along those lines, most of the states didn't have popular votes for presidents. They just had the legislatures appoint the electors, and the electors would go vote.
Okay? Right, because, and some people are weirded out by that, but you think practically it's like, what it's 1796. They're like, what are these people voting for? Like, how do they vote practically? They're spread out across a bunch of wilderness. It's a big pain. And then otherwise, how do you even campaign? Like, what's
well, but it's even a more rudimentary reason. All right, let's think about it this way. Before our Constitution was ever amended, if you wanted to vote for the House of Representatives, you would vote directly for your representative, right? Okay. If you want, and then to elect your senators, you would elect your state legislatures, who in turn would appoint the senators. So you're one step away from your representative. You're 2 steps away from your senators. Okay. Well, now watch this. When you're electing the president, you're electing the state legislatures. The state legislatures elect the electors. The electors elect the president. So guess what? You're 3 steps away from the president. And then the courts would be 1 step beyond that, because they would be appointed by the president and confirmed by the Senate. So you had this gradation where on the one end, where at the representative level, the people, if you will, you have the democracy of actually going and getting, but on the other side, you have more of a republic. And it was a gradation between democracy and Republican ideals, that balance the risk against mob rule, against the risk of tyranny of the elites and whatnot. Okay, so suffice it to say, the legislatures could appoint the presidential electors at any in however way they want to.
Right.
And so
in theory, they could do that, and like they could go back to that system in theory.
Right. So for them to say in Georgia that the electors that Trump and his people committed some sort of RICO violation by asking state legislatures to change the vote, presupposes that the vote of the people for electors was supreme compared to what the legislature could say. And the 12th Amendment says the complete opposite. The 12th Amendment doesn't even contemplate people voting for president. It's the legislatures who pick the presidential electors. And so that is the ultimate safeguard against election fraud, because the legislature, I believe, this is what I honestly believe, if I were in the Mississippi legislature, or if I were in control, I would create some sort of uniform law that the states would vote on that say, okay, we will allow, as legislators, the people to pick the electors just like we already have. But if there is ever a situation where the margin of error is less than 2% or less than 5%, just some arbitrary number, okay?
Sure.
Then the election is thrown out and the legislature will pick the electors, period.
Yeah. Yeah, and presumably they could do that.
And I think that would be the safest bet, okay?
What about this? Do you think California could get super cool and they could say we will issue our electors only on the vote of undocumented persons? That's a challenging one, isn't it? Because if they have plenary authority to choose electors in the manner that they decide, they hold a vote. They only allow undocumented persons to participate in the vote, and then they choose the electors that way. It's just a referendum.
I guess in theory they could. Now,
that'd be fun. I think they should try it.
The only caveat I have against the plenary power of the legislatures is that, there is this electoral count compact that a lot of states have entered into, saying that we'll throw the votes based upon the popular vote.
Right.
That compact, I think, is unconstitutional, because at the end of the day, states cannot enter into agreements with each other without the federal government's approval.
Right, and that's Article 5, right? It's either 4 or 5, I thought.
Something like that. So I think that
except when they're invaded.
Except when they're invaded.
So if we invade all of the state compact states at the same time, then they can do it.
Right. So President Trump is doing what he needs to do to try to, again, keep in mind, all of these lawsuits. Now, granted, he's using his private attorneys to do it, but here's another thing: Jack has indicted him for trying to get the Justice Department to do this stuff. Well, again, he's the president, and he has an affirmative duty under the law to prosecute and to promote election integrity. And you're telling me that as president, he can't tell the Justice Department to go and investigate election fraud that he thinks has happened?
Well, the amazing thing is they will simultaneously claim that he's improperly utilizing the Justice Department to do this, and then say, well, this also isn't an official act. It's like, well, okay, if he's invoking the Department of Justice, that at least falls under the outer perimeter. Now, you would have to prove that it was an unconscionable use of the Justice Department to do this, but then you would have to ask, why did everyone in the Justice Department go along with these requests? Or I shouldn't say everybody, some of them stepped down, they chose not to, but so many Justice Department members did go along with this. It's like, well, that points to an official act of the president to me. And also, again,
of course it does.
Investigating federal election fraud of the president of the United States seems like something that the Justice Department would be at least involved in as a partnership agency, I would think.
Wait. Did you listen to this for a second? Did you happen to read the Supreme Court opinion that came out today about official acts and Facebook pages and stuff?
No, I did. I saw the headlines, and that's the story I'm probably going to be covering next week, but I didn't read it.
Well, I was, when I was riding in the car, my wife was driving, I was reading that opinion. It was a very short opinion. Amy Coney Barrett did a magnificent job writing it. And but the basic gist is that under certain circumstances, if I'm a political figure and I'm using my personal Facebook page to communicate certain things that run pertinent to my office, in certain circumstances, it's a fact-intensive inquiry, I may be acting as a state actor, even though I'm using my personal page. Okay.
Right.
Now, I'm using that as an example to back up to Trump to say, I would go a step further that if I'm the president and I have a duty as the only person in the executive branch to promote election integrity, okay, if I want to use my personal lawyers to do it, that's fine, because in that sense, I'm still a state actor, or a federal actor in this case, okay? So at the end of the day, I think this isn't even an outer perimeter situation. I think because of the National Voter Rights Act, what President Trump was doing in 2020 was official acts, period. Because,
well, if you don't want a president using personal lawyers in these decisions, it's very simple. Provide the president with criminal immunity, and then White House counsel would be sufficient at that point. But until you rule that the president has sufficient criminal immunity for his official acts, then you would necessarily have to have personal attorneys to give you advice outside of the White House counsel's advice, because they're representing the office of the president. Yeah. And your lawyers would be representing the person of Donald Trump. So you have to eliminate the disambiguation between those two if you want to eliminate personal lawyers'
Exactly
involvement.
Right. Exactly right. Now, I take it one step further. Okay. Let's say you're the legislature votes a way you want and you don't like it or whatnot, or maybe they vote the way you want and then the other guy doesn't like it. Well, the next step would be to get to Congress on the January 6th situation. Okay.
Right.
Now, January 6th, under the rules that were in place in 2020. Now they've amended it after what happened in 2020, but under the rules that were in place in 2020, you had to have one member of the House and one member of the Senate to object in writing to an elector, a slate of electors from a given state. And then both houses would convene separately. And if they both voted to throw it out, the votes would be thrown out. Okay. All right. Now, one of the things I mentioned in my brief in passing, and I cite to 3 law review articles that support this. One of them was done in the right after the year 2000 election. And I want to say that, can't think, but some big names on the left were actually helping this guy write this opinion, is what I'm trying to say. Okay.
Right.
But these law review articles are of the opinion, and I tend to agree, that the Electoral Count Act of 1887 is unconstitutional anyway. Have you ever heard of that as a possibility?
Ooh. No, I've never thought of the Electoral Count Act as unconstitutional.
Yeah, let me tell you why.
Yeah, please do.
It's the doctrine of legislative entrenchment. Okay, now follow me on this. The Constitution says that the House and the Senate can make their own rules. Okay,
right.
They have the power to do that. And prior to the enactment of the Electoral Count Act of 1887, back when we had the Hayes-Tilden conflict in 1876, okay, the rule, there was a joint resolution that went into place that basically said that both houses had to agree to either accept an electoral vote or reject it. I can't remember exactly. I should have looked at that a little bit more before I got on the horn tonight. But
yeah, do your homework next time, Matt.
Well, I did do some, but those were House rules. Okay. Now we had what the Electoral Count Act does, however, is it codifies those rules into statute.
Yes.
Okay. Well, there's a doctrine in the law called legislative entrenchment, which says a current legislature cannot tie the hands of a future legislature.
Okay, sure. Yeah.
So think about this for a minute. By even amending the law like they did in 2021 to make it even harder to object to these electors, the Congresses have made it harder for the next Congress to change that law, because now, not only, whereas before, if it were just a House rule and a Senate rule that could be changed by a majority vote, next time somebody comes into office, that'd be different. Okay.
Yeah.
But by making it a statute, you have to get the president's approval now to change the rules of the House and the Senate. And guess what? If the president doesn't approve it, now you've got to get 2/3 votes of both houses of Congress.
Yeah,
so
that makes sense.
So that is an unconstitutional legislative entrenchment. Now, Vice President Pence could have done something about that, because I want to say Louis Gohmert and maybe a couple of other folks actually sued him for a declaratory relief to basically say that, the Electoral Count Act was unconstitutional. And that statute was going to be presented, but the Supreme Court, or it may not have been the Supreme Court, it might have been the D.C. Circuit, I can't remember, but basically said that the only person who has standing to make this argument would have been the vice president. And he was actually objecting to this because he was wanting to say that the Electoral Count Act should still be constitutional.
Right.
In other words, Pence could have actually just said, hey, guys, let's let the Supreme Court decide this for us. But he didn't. Okay.
Shouldn't you get to have shouldn't you get to file as intervener then? Like at that point, isn't that how you normally tackle that? There'd be an interested party who could file as intervener, which would then
interveners, but the interveners here were the members of Congress, and they didn't have standing. Apparently, is the point, because
these damn standing requirements are ridiculous.
I know, and that's the thing that just aggravates me. Now let's go back to the pre-Electoral Count Act. Let's say that the Electoral Count Act is thrown out. Let's say it is unconstitutional, like I say it is. Okay, all right. Well, back in 1875, the vice president at the time was a guy named Henry Wilson. Henry Wilson died of a stroke. So because we didn't have a 25th Amendment, we didn't have a mechanism to appoint a new vice president. So in 1876, when this drama happened, the president of the Senate was the president pro tempore, and that was a gentleman, Thomas W. Ferry, from the state of Michigan. And Senator Ferry, president of the Senate, Ferry, was a Republican, and his position was that the 12th Amendment only says that the president of the Senate is the one who counts the votes, and that everybody else is just a spectator. And his position was, I can count whatever vote the way I want to count it. Okay?
Right.
Now, the Democrats that run in the House didn't exactly like that. And they already had these joint rules that went back to the 1860s that would have gone in favor of Tilden becoming president, if you want to get right down to it. And so that's why they created this commission that had 15 people on it. And finally, they gave the presidency to Hayes in exchange for Hayes ending Reconstruction. Okay. All right.
Right.
But the point I'm getting at is, if you had followed the principle of what President of the Senate Ferry said in 1876, then Vice President Pence could have looked at the votes from Georgia and says, listen, I think there might have been fraud in procuring these, and throw them out. Now, could he have said, I want to take these alternate ballots? Probably not. Okay.
No.
But
I've never thought that the vice president could do that. What I thought that the alternate ballots were the purpose that seemed to be asserted, and the purpose that makes the most logical sense, was there is some constitutional date to submit slates of electors.
Yeah.
Now we have submitted a slate of electors that is in the alternate. And if the original is thrown out, theoretically, the Congress of the state that has been challenged could say, actually, we'll adopt this slate that's been submitted, and you can take that one and count it.
Right, right. So, but let's say Pence had thrown out those electors, okay? Well, then it would have gone to the House to select the president and the Senate to select the vice president. Now, understand this to your audience. When the Senate selects the vice president, it's an every man for himself voting, okay? But when the House selects the president, it's not every representative voting for himself. Each state gets one vote. California gets one vote. Mississippi gets one vote. Wyoming gets one vote. Okay. And if you looked at all of the congressional delegations back in 2020, Donald Trump would have won by a landslide.
Yeah. Now, something like 38 Republican states at that point.
Now, we had a 50-50 tie, I believe, in the Senate, or pretty close to it. I mean, Pence might have been hard pressed to vote for himself for re-election. And I could, listen to me, I got to give Pence some credit on that. If that were the case, I would have felt very awkward voting for myself to be reelected. Okay, I'm not going to deny that. But as tense as it was in Washington back then, I mean, you might have even seen a couple of Republicans saying, forget this, I'll vote for Biden, I'll vote for Harris. So you could have ended up having a situation where Trump would have been president and Harris might have been vice president under that dynamic. You know, if you think about it, if everything had gone according to the Constitution in 2000, that's exactly what would have happened. You would have had Bush as president, but you would have had Lieberman as vice president, because you had a 50-50 tie, and Al Gore was the vice president still at the time.
Right. Yeah. So, and that's actually how the people are kind of weirded out by the idea of like that happening, but that is how kind of the president and vice presidency used to go. You would tend to have the number two person end up as vice president because of how the counts were until they amended that. But you would, funny line in Hamilton was like, I don't want to work with my opponent from Jefferson. He's like, we got to change that. It's not going to stick around.
So you see, so assuming that there was a good faith basis to say that the Electoral Count Act was unconstitutional, assuming that, you know, you're following Bush versus Gore, assuming that, you know, you have a good faith basis as best as you believe there is to go into federal court and argue that there's election fraud, then the president would have been acting in good faith all through those steps, even if he had been mistaken. Okay.
Right.
And since it is his affirmative duty to promote voting rights under the National Voter Registration Act, then it stands to reason that trying to fight election fraud would have been furtherance of that right. And therefore, each of those steps would not have been in the outer perimeter of his actual duties. It would have been square in the middle of them.
Right, of course. Yeah, I agree
so,
with that.
Because it was square in the middle, then Marbury versus Madison tricks in, and the judiciary branch cannot question what the president has done. So in that sense, because the president was acting in good faith to perform his duties back then, added to that the fact that it's obvious that President Biden is acting in bad faith, he should be given immunity. And this case in D.C. should be thrown out. The case in Florida should be thrown out. And given the issues related to the Georgia legislature and the other issues there, that would have an adverse effect on the Fani Willis case. About the only one it might questionably not have as much of a case on to be the Alvin Bragg case, but it would have it on some of those issues. Okay. So I think the Supreme Court could actually, Lord willing, pull out a hat here. But I see where they're kind of concerned too, because they don't want to send a message that, okay, presidents can do just whatever the hell they want whenever they want to, and they can't have any consequence. Like I was saying, the hypothetical of dropping a nuclear bomb on Parliament Hill in Ottawa on the last day in office. But if you've got a mechanism like impeachment and removal, or impeachment and conviction, to be more precise, as a way of the people giving their voice to say, okay, guys, we don't like this, you need to do something about it, then you could go after that president, and you've preserved the republic in the process.
Yeah, it's really the Supreme Court is in a precarious position. Because like you said, there are these things that we get to conceptually where we go, okay, we don't want a president to do that. We want a mechanism to stop that thing. And impeachment may not be sufficient, but at the same time, we have to ask, like, can we allow these prosecutions to run rampant? And the main reason this question is unanswered because there's almost like a handshake agreement to never do this. That's just gone. 185 years, they haven't ever done this, or I think it's even longer now, but they've never prosecuted via felony indictment a president. I think one of the only presidential prosecutions was actually Grant, it was a speeding ticket.
Yeah, it was a speeding ticket. That was it.
In a carriage, which is funny. I want to ask.
By the way, before you say Grant, let me tell you something interesting about President Grant that you're not going to believe. Where is his presidential library located?
Oh, let's see. I'm going to say it's in Richmond, Virginia.
No.
I have no idea. Where is it?
Starkville, Mississippi.
Oh, there. Okay.
At Mississippi State University.
Oh, my goodness.
His presidential library is at Mississippi State University.
Well, there you go.
See, what happened was the Grant family was supposed to, they were going to send it to some school up north, and this committee of professors were getting it already, and then the school fired one of those professors, and our president at Mississippi State was on this committee and said, hey, listen, wouldn't it be funny, since Grant invaded Mississippi, if we had his papers here at Mississippi State? It was our way of trolling the Yankees, okay?
That's a good way to do it. I wonder when we get to tear down his statue.
But you were saying, I interrupted you on Grant and the speeding ticket.
No, I just thought it was funny. Like that's the only prosecution. And I thought, I was like, I never considered speeding tickets with carriages, but I guess they've been around. Those annoying laws have been around that long. Here's Matt, I am loving this discussion. I have to go to the bathroom real quick. I'll be right back. And I got to refill my, I've been drinking sweet tea, heavy cream and vanilla, which is delicious, by the way. So I'm gonna get a drink. I'm gonna go to the bathroom. Do you want to stay and just talk to the chat for a minute?
Oh, I could. I would love to talk to the chat now. I've got to actually get back to the. Do I hit this chat button on StreamYard and I see it, or Oh, where I see oh, yes, 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 yes,
Yeah,
yes,
you can
yes,
see
yes.
you can see the
Okay.
comments there. So if you want to
Okay.
talk to the chat for just a few minutes, I'll be right back. When I get back, I want to do I have one major question about your or about the extent of presidential immunity that we haven't talked about, and that's the federalism question I was talking to you about before stream, and that relates to Fani Willis and Nathan Wade.
Sure.
And then I want to go into Fani Willis and Nathan Wade. This discussion is fantastic. To the chat, guys, you've sent in several super chats and memberships. Thank you so much. I will get to those, but I really have been just jiving on this conversation with Matt, and I don't want to break it up too much. We will read those, even if it's me reading them at the end of the night. We'll get to them, but I'll be right back. I'm gonna just make you giant for a minute, and that way you don't have to, like, since you're like doing a case and you've got an amicus brief, I don't want to have you talking to my Mohammed image that I usually put up. So, but yeah, if you want to talk to the chat for a few minutes and talk about this stuff, it's fascinating, and you know so much about this. I'll step away for just a bit.
That's great. That's great. I feel almost like Ed McMahon filling in while Johnny's putting the Karnak the Magnificent hat on in the background. And I'm standing over here doing the Alpo commercials. But all right, so let me see what we got here from Grifty. By the way, I got to take my glasses off to read because my bifocals were put on the lens wrong. Does Matt have an affinity for cantaloupe? Sorry, I know I'm an asshole, but it's the voice, all love. I wouldn't say I have an affinity for cantaloupe. I tolerate it. It's okay. I guess it's all right. Yeah. Let me see. Can I get a toast for my cyber law exam? I'm going to let him do that because I didn't bring any booze. And frankly, all I have is the Powerade and the Pepsi I've been drinking on right now. America needs 100 Matthew Wilsons, and I'm being modest. Well, that's very kind of you, WS, and I'm sure Nick is going to appreciate the kind super chat you're giving. Toast to the freedom fighters coming out in all their different roles to stand up and speak, and God good and sends his army. Romans 12:19 in real time. By the way, I see the Canadian flag. Sorry about the jokes about nuking Parliament Hill. Okay. It just seemed like the least likely person that we would just nuke. I didn't realize Ted Cruz was master of disguise. I do kind of have that high-pitched voice, don't I? Biden, greatest. Probably don't need to be cussing too much. Like I said, I'm a substitute Sunday school teacher. Why are people still doing the Fauci nonsense? The U.S. health mandates ended because of court decisions, and most people got tired of them, yet face napkins are a thing in 2024. It's legal, but also stupid. Well, in general, I agree with you on that. But I would say you might want to extend a little bit of grace in this one respect. There are some folks who put the face napkins on because it has nothing to do with COVID. I'm not trying to get too much in my business here, but last year, one of my nephews died of cancer. He was 37 years old. And, near the end there, if he had to go anywhere, like when he came to my mom's funeral and my dad's funeral, he had to wear a mask and stand 10, 15 feet away. So, having gone through that, I recognize that there are probably some people who may be wearing these masks that have nothing to do with COVID, though I tend to agree with you that it's probably in the minority and that most of the people who are wearing them, especially the ones who are wearing them in the car when they're driving, alone, I see where you're coming from, Lover of Grain. Law Watermark, I remember Matt. Good to have him back, Nick. Well, thank you very much. I'm glad to be back. I think the last time I was on here, we had a whole bunch of legal giants chatting, and I stuck my head in every now and then. But when you got all these other folks who were talking, who have their own shows and whatnot, it seemed more reasonable to let them do a lot more talking. Those are all the super chats. Let's move over down to the lives. Let's see what we got here. Let me see. Let me see. If I hire a lawyer and he has an emergency and can't show up, is he allowed to subcontract to a different law firm without my knowledge? Dennis, that's a question that probably varies from state to state. Let's see. Nick is drinking Long Island iced tea. That might be the case. I don't know. The legal giants avoid him now. Well, maybe so. Matt, how do you feel about an amendment to lock SCOTUS at 9 and force lifetime appointments? No retirement, no removal for health. I'm not too fond of that. I think there's some things that we just need to do by tradition. Hubby passed from pancreatic cancer in 2020, just before COVID got back. God bless you. God bless you. That's awful. 2020 was just a rough year for everybody. I find you highly insightful and fun to listen to. Thank you. Thank you for the appreciation there. Let me see here. Okay, well, yeah, I did. Yeah, look, I think he just cleared the super chant, David Markham. Yeah, maybe I did. You know, let me see. Why bother with a mask? And you would think that turtlenecks would have to come back. By the way, all right, listen, before I get into the chats, since I'm waiting on him to come back, I got to tell y'all a funny story. Y'all want to hear a funny story, a funny law story that has absolutely nothing to do with any of this kind of stuff? Okay. All right. So, you didn't. Okay. Matt, what do you think of the Jesuits? I don't know. Okay. I don't have an opinion about the Jesuits. Okay, so here's the funny story. Many years ago, I was an attorney in a very, very, very small town, college town, Starkville, Mississippi. And I had a matter in Chancery Court. Now, Chancery Court in Mississippi has a bifurcated Chancery and law situation where you've got anything that has to do with what I call LSD, land, sex, and death, land disputes, marriage, divorces, and child custody and probate would go to Chancery Court, and the criminal and the civil matters would go to Circuit Court. Okay. All right. So I had a matter in Chancery Court. It was a child custody matter. And I had a case where the other attorney was a very, very, very busy attorney. He had another job somewhere else that he had to do. And as a result, he had to make sure that every time we went to court, he was at the very, very first place setting in court. Well, I was charged with the duty of scheduling a court hearing, and I got a second place setting. And I knew that this attorney was going to get all upset with me. He was going to move for continuance, and I knew that my client was going to get mad at me. And Lord have mercy, we were going to have a problem. So I decided, okay, well, I got to do something about this. So I looked at the docket to see what was the case ahead of us on that day. And I recognized that I knew both of the attorneys. And in fact, I not only knew both of the attorneys, I actually knew one of the parties. So I walked to the office of the attorney whose party I did not know. And I walked into her office and I said, hey, so-and-so, what about this case you've got tomorrow? What have you got going on for that? Tell me what's going on. And she and I were talking, and I says, well, what would you like to do and to settle this case? And the lady attorney looked at me and she said, well, we would like to have A, B, C, and D. I said, okay. So I went back to my office and I called the other attorney. And I said to the other attorney, I said, hey, listen, bring your client to my office. So both of them came to my office on short notice. And they're sitting down at my office. And I asked her, I say, hey, listen, would you be willing to settle this case tomorrow for A, B, C, and D? And they said, sure. And okay. So the next morning, they settled their case. I mediated somebody else's case, got it off the docket, just so that I could have a first place setting. It's normally more of a funnier story when I'm not doing it on YouTube, but I hope y'all appreciated that. Never did LSD, but shrooms smooshed down doors. Yeah. The circles above his head look like musketeer ears. That might be, I think that's my bald spot. Great lawyer. I appreciate that. Thank you. Did everyone clap? I hope so. Thank you for the good story. Did many judges openly say that even questioning the election would undermine the whole political system? What kind of argument is that? Even questioning the election would undermine. I don't remember what the judges said with respect to that, but I do know that if you're a lawyer now and you're not able to prosecute a case without fear of losing your law license and going to jail, then you're never going to go and do that again, and we're never going to be safe. What's that next super chat we got here? I don't know. I mean, does Nick know you're reading the super chats? LOL. Probably not. But this is what happens when you give the substitute teacher the keys to the car. Right? You never know what'll happen. Look deep in your eyes and ask, and he will never ask you. Okay. Nick won't care. Why would we? I don't know. Thank you, Matt. You're a champ. Not easy entertaining a bunch of chatty Cathys. Well, thank you. Let's see here. Matt Wilson knows. Well, if you say so, I'm humbled that you would say that. Let's see what else we got here. Does Mississippi have Prince Albert in a can? Used to years and years ago, but I can't remember. I don't. My dad, he's been dead for about 3 years, but he quit smoking pipes in 1982, so I don't even remember what. He was a Carter Hall guy anyway, but that was 40 years ago. Why would they give the keys to the car to the substitute? Well, you're right. Look, it's 1 a.m. My analogy suck.
Damn. Wow, that was rude.
What?
No, not you.
Huh? Oh, wait a minute. How do I get back on the thing that I'm doing here? I'm trying to. I hope I don't. Do I hit this button? Oh, there we go.
We're back. Sorry.
That's okay. Sorry, I was having fun. I was reading your super chats and clearing out the table for you.
Presumably you were doing great. No, I believe it.
Told it what I thought was a funny story. I hope it was. It was funny when I tell it in person, but it's kind of hard to tell if you're getting the feedback, and if it's funny when you're doing it on a super chat. At any rate,
look, I appreciate you so much because, like, I jokingly said, "Yeah, do your homework or whatever," but like you're sitting here now. Let me tell you about 1867. I'm like, oh my god, like, I'm not prepared for this Jeopardy answer. It's no, you know so much about this subject, and obviously, of course, you've just written a Supreme Court brief. I'm guessing you've got a lot of fresh information up there swirling around. When you're writing amicus to the Supreme Court, you're not lobbing it up as a softball. You're knocking it down. And again, I haven't read through your entire brief. I've skimmed some of it, and I'm going to probably read through it on Monday because I think it's something really important for people to see. But one of the questions I want to ask you about, and I think this will be a good lead in and to the next topic, but I do want to give you an opportunity to say anything more about your brief and the immunity questions that aren't answered here before we do. But this will lead us into Nathan Wade and Fani Willis, I think, and the Fulton County prosecution is. As far as presidential immunity, let's assume the Supreme Court says, yes, presidential immunity exists for criminal cases to some degree. Let's assume that the Supreme Court goes, okay, well, we're going to extend it in the same way as we extend civil immunity, which means immunity from anything within the outer perimeter of acts of the president. So anything that could conceivably plausibly be an act of the president is presumed an act of the president, and therefore he's immune from prosecution. And it's not like you get to quibble over it in the courts, because that defeats the immunity argument. I mean, basically, if there's the barest take that this is an act of the president, then it is. So let's say they do that. Does this extend through state prosecutions as well, which is a federalism question versus a Republican question that we have with separation of powers between the judiciary and the executive? Federalism, of course, being with the executive versus state prosecutors.
Well, let's think of it in these terms, okay? If under Nixon versus Fitzgerald, you can't sue a a former president for money damages because he's absolutely immune, presumably you couldn't do that in federal court. What makes one think that they'd be able to sue in state court? Okay.
Well, the difference I would say, the only difference I would say is that, again, if they derive immunity from civil suit, which to my understanding, it is derived as a separation of powers between Article 2 authority and Article 3, then you have a Republican separation of powers question, but you don't necessarily have a federalism separation of powers question, and the states as sovereigns may be able to bring criminal charges under state statutes. And then I'll reinforce it with the concept of if we look at federal criminal immunity being not only a separation of powers issue, but maybe just a passive application of the power to pardon.
Well, let me think of it in these terms, okay? Let's go back and let's use President Biden, sitting active President Biden right now, okay? If President Biden was found to have violated Delaware law by not filing, well, I don't know what kind of tax things Delaware does, but let's say they have some sort of tax law that he didn't pay his property taxes right on his mansion or something like that, okay?
Right, sure.
All right. I don't think that the state of Delaware could prosecute a sitting president, because if he did that, in this hypothetical, you would be using the power of the state to usurp the presidency in the same way that you couldn't have, let's say, a representative who's driving from Mississippi to D.C. get pulled over and be detained and arrested in Virginia. Okay,
sure,
because you would be one state would be using its state police power to usurp the federal government and hold the federal government hostage, okay?
Right. That's a sitting president, though.
That's a sitting president. Now, if, however, that same immunity attaches to a former president for acts that he committed while he was president,
right?
Okay, then I would have to say the supremacy clause would still apply, and federalism principles would be trumped, no pun intended, by the supremacy clause, and therefore a president who has committed an act that might be arguably be considered a violation of state law in furtherance of his duties as president or in the outer perimeter while he was president would still be immunized because he was because of the supremacy clause of the Constitution. You see what I mean?
Yeah. I get what you're saying, and I think I agree. One of my just concerns, and the reason I bring up that question is because it is essentially a different question, state versus federal prosecution. There are different constitutional questions involved, and so I just was curious if the states but what if the states assert what a 10th Amendment, 10th Amendment claim and say, actually, no, you're taking away our authority to enforce our own laws. Now, maybe they would abide by, federalism principles say we can't hold hostage the federal government by prosecuting a sitting president. But basically, our statute of limitations would start the moment he leaves office, and then we would have full authority under the 10th Amendment to prosecute him and go after our laws. I mean, that would be a relevant counter argument, I would think.
I think that could be a relevant counter argument, but even then, the 10th Amendment is subordinated by the express enumerated powers of the federal government in the Constitution, including the necessary and proper clause.
Right, yeah.
And
because that's the 10th Amendment is like
right.
Powers not delegated are reserved.
You're right. And I think, I guess, let's look at the extreme and work our way back here, okay?
Okay.
Let's imagine for a moment that President Biden, and I use him not because I don't like him necessarily, but just because he literally is the president right now, okay? Let's say that President Biden comes to Mississippi, and for whatever reason, he talks the Secret Service out of and into letting him drive his Corvette. And he drives down Interstate 22 in Tupelo, and he's going 95 miles an hour, and he's swerving like crazy. And we're not talking just regular negligence. We're talking gross negligence. And he sees somebody with a car, and they've got a MAGA plate on, and he decides, I'm going to take the tank and just ram into this person, okay?
Sweet.
And it's a deliberate murder. Okay. One could make the case that that would not be within the outer perimeters of his duties. But then again, because he's president, that would still be kind of a high crime and a misdemeanor that he could be impeached and removed for. And let's think about this for just a minute. And I just thought about this. When, up until, late 1800s, mid 1800s, I mean, for years and years and years, there was a strong reluctance in Congress to create a United States code because they didn't want to have a whole bunch of federal crimes. I mean, in fact, we didn't even have a federal crime for, presidential assassination until after Mr. Kennedy was killed. Okay. And so there were, when on November 22nd, 1963, that was a Texas murder. Okay. Right. It was not a federal crime. So I said all that to say, if you go back to the late 1700s, early 1800s, just about every high crime and misdemeanor other than treason or bribery would have been a state law crime.
Sure. Yeah.
Okay.
Yeah, Scalia's talked about this when he talks about the Eighth Amendment and the death penalty. And he talks about how at the founding, every federal felony was potentially punishable by death. And so he talks about finding any death penalty applications violative of the Eighth Amendment doesn't make sense. But what Scalia is talking about, like in that context, is that there are only like 6 or 7 felonies in the federal 6 or 7 federal felonies for quite some time. Like it wasn't like today where there are hundreds and hundreds of statutes.
Well, plus on the death penalty, is it the Fifth Amendment, or, it talks about that no capital offense can be tried unless you have I can't remember, but one of the, I think it's the Fifth Amendment that actually speaks of capital offenses. Well, the fact that the Bill of Rights speaks of capital offenses presupposes that there are some offenses that somebody would die from.
Right.
So that would put a kibosh in the whole, Eighth Amendment argument of cruel and inhuman treatment just by killing somebody. Okay. But you're right. There was only about 5 or 6 different felonies. And so that being the case, I would say that if you have committed a state law crime, that still would have fit under the rubric of a high crime and misdemeanor that you could have been impeached and removed from office for. And so that goes back to the thing we're talking about with the presidential immunity. I think presidential immunity, if it applies to President Trump in this case, applies to him both federal cases and to definitely the Fani Willis case and to some degree perhaps the Alvin Bragg case.
Yeah, I think again, assuming the Supreme Court stops at acts as president for immunity, I think it would necessarily have to apply to the states as well. I think there'd be an interesting argument from some states saying that that it shouldn't, but I think they should ultimately lose that, and that it should be there. I just find the concept a little bit interesting, but I also find the concept really interesting. The idea that as this 14th Amendment question was pending before they ruled on it.
Yeah.
The idea that if Trump had come and he was we're going to get some votes in Minnesota, I'm going to come to Nick Rekieta's town. He's a popular YouTuber or whatever. Like if he would have come out here, to my county is 50,000 people. And so if he would have come out here to my county and he would have spoken about voter fraud or something in the county, and people would have rallied up and gone and gotten really mad and attacked like the courthouse here, maybe gone to the city hall of Wilmer, if they'd gone even marched into Minneapolis and caused trouble with a federal building. So could a state level prosecutor, after he's out of office, I guess, charge him with incitement to insurrection? Could they do that, or could they charge him with some sort of crime in Minnesota and potentially, again, raise this question of, can the president even go speak in this tiny little town? And you've got a county attorney in a population 50,000 county holding the president of the United States' feet to the fire. And to me, I'm like, is this what we want? Is this the system that makes sense? And I can't get there. That's where I keep coming to this presidential immunity question outside of all the legal things, is from a practicality standpoint, can we have what's going on with Trump right now? I mean, this shit's been going on for years, and he's been out of office. Like, we're at the next election, and it's all still just brewing and building. And it's like, what are we doing here? If he wins, this could still be going.
I think this validates everything President Ford did in September of 1974 in pardoning Nixon, if you want to get right down to it. Because President Ford, I don't know if you remember this or not. Well, I mean, you probably don't remember it. I don't remember it. I mean, I was only an infant when this happened. But President Ford actually went to Congress personally to testify, to explain why he pardoned Mr. Nixon.
Right.
I mean, you got to take your hat off to Jerry for that.
Yeah.
I mean, he took the Truman saying the buck stops here. He took it to heart, and
he basically says, like, we cannot, like, this just is too messy. Like, we got to move on. We got to go.
Because he said he was spending 25% of his day worrying about one man, and this was the very same time he was,
gay.
He was what?
I'm sorry, I couldn't help it.
Oh my goodness gracious! We're having. So anyway, I digress. He was spending. At that same time, of course, you had the situation in Vietnam where Ho Chi Minh was gradually starting to send folks, back into Saigon, and Ford was distracted because he was too worried about Nixon and all this other kind of stuff, and it was just he had to do that, and frankly, if you go back to what we said at the very beginning of the thing, in the purest sense of the term, Nixon shouldn't have been prosecuted because he was the president.
Right.
You know what I'm saying? I mean, of course, he was an unindicted co-conspirator, so he was not actually indicted, but still, at the end of the day, no, you can't. The president is not above the law, but the law that he is governed by is different from ours, because in the same way that Congress cannot come after us individually, Congress can go after him individually. You see what I'm saying? And likewise, in the same way that the FBI can't go after him individually, the FBI can come after us. You see, I mean, there's a different kind of accountability for him compared to the rest of us. But at the end of the day, it's still accountability, and it's a high level of accountability, actually.
Yeah, absolutely. And I mean, that's the whole purpose of immunity at the end of all of this. Same with the civil immunity is there's this high level of accountability. It takes a lot of focus, and we cannot have the executive, their literal definition of their role is to execute. We cannot have them second guessing and questioning every single decision, wondering if maybe not now, but 2 years from now, when they get out of office, if they're going to have to face, the damn shackles for every single word, statement, thought, speech, action, consideration, conversation. I mean, when you get into what you could say about a president, if you have the authority to prosecute them, I would contend that every president has committed some sort of act that someone could find criminal enough to prosecute them for. Even if you just think about their regular actions as the nation's primary ambassador, like, they're going to talk to nations that are hostile to us, at least in negotiations of some form or another. So is that all like treasonous discussion, with an enemy of the state? We can't have that. It's impossible.
Plus, we have so much selective prosecution even in that area that reminded me of the Logan Act. And it's like, they went after General Flynn over the Logan Act and all the conversations he was having with his counterpart as National Security Advisor and trying to work things out. And they wanted to hit him and hit him hard. And yet every other National Security Advisor coming in on a transition team did the same thing. And nobody ever prosecuted them on the Logan Act. I mean, it's like the rabid hatred that I hear for President Trump seems to justify anything and everything anybody wants to do to him. Now, does he bring some of it on himself? Yeah. But at the end of the day, I've come to realize that President Trump is kind of like a it's kind of like the dye that you're injected with when you go to the X-ray. Okay.
Yeah.
I mean, what he does is magnifying and illuminating all that is bad and all that is good in our government and in our society. Okay. And, you know, I think, I mean, his administration has probably been one of the most momentous administrations in the last 50, probably going back to maybe FDR, if you want to get right down to it, because I can't think of anybody as momentous, as consequential as he in you know in the reactions that the Americans have had for him, both for him and against him. You know what I mean?
Right. Yeah, and certainly in regards to Article 2 jurisprudence, I don't know that there's ever been a president as potentially impactful. I mean, where else are we defining these concepts that have existed just written down with that are all novel legal questions for the court to decide? And I love that about Trump. I love that about this. And I don't care if people like him or not. That's irrelevant. And it wouldn't matter what party he had or what platform. The fact that he is drawing these questions out, forcing the answers just by not only his actions, but his personality that has been so invective, I guess, towards these other for these other people. They must act against him. They must, to the extreme. And with that, I want to go into Fulton County, Georgia, Nathan Wade and Fani Willis. This prosecution is over election interference, although, I mean, I have fundamental problems with the prosecution for reasons we've talked about. So let's not dwell on those too much. I want to know today, a huge impactful decision dropped from Judge Scott McAfee about Fani Willis and Nathan Wade and their allegedly improper relationship and the appearance of impropriety and all of that. There's serious questions about whether or not they should be on the case. And he issued a decision today. Can you give us a little taste of what he said?
Well, he pretty much said that, Fani, you can stay, but Nathan, you can go, because...
Or Nathan, you can stay, but Fani, you can go.
Well, think of it. No, actually, think of it this way. Strictly speaking, if Fani goes, Fani would have been referring this to the committee in Georgia, in Atlanta, that would have picked a new prosecutor, which implicitly would have meant that Nathan would have had to go anyway, because the next prosecutor wouldn't pick him as a special prosecutor, because from what I understand, Fulton County, Georgia is the only county that really hires special prosecutors for any reason. And they're the only ones with the budget to do it.
But what if he was having sex with that prosecutor?
You know what it reminds me? This is almost like saying we need to fire Monica, but we can keep Bill.
Yeah.
I mean, really, if you get right down to it, I mean, the thing that was the most. Let me back up for just a minute, okay?
Sure.
We've got a very young judge. He's 37 years old. Okay.
Yeah, he's young enough to work for Fani Willis and donate to her campaign.
Well, yeah, and I'm, having worked in small town. Now, granted, Atlanta's not a small town, but in a chancery court environment where, while you were in the bathroom, I was explaining to the audience in Mississippi, we have a completely bifurcated law and chancery system. Completely, okay. We have chancery court and we have circuit court. And in chancery court, you have bench trials and whatnot. So I spent most of my career doing chancery-related things. And one of the things that I've noticed about judges, especially in chancery court, is, if you can make a decision that pisses off both sides, you've probably made the right decision. Okay, and there's that temptation to always try to split the baby, to try to placate both sides to see if you can make things right. But if you depending on how you try to cut the pie or cut whatever you're trying to cut, you can cut it the wrong way and cut it in half, and it don't do anybody any good. Okay. And this is one of those situations where it makes no sense to say that I have the power to tell a prosecutor you can't be on the case because of an appearance of impropriety, and therefore, Mr. Wade, you have to go because of an appearance of impropriety. Oh, but by the way, the boss that you've been having sex with, the boss that was accepting gifts from you that she should have put on her reports and she never did and has never amended them. Oh, by the way, the same boss who, in my opinion, I'm chiding for making extrajudicial statements that could be prejudicial to the court, I'm going to let her stick around. But there's an appearance of impropriety. You need to get the heck out of here.
Yeah, this decision was so crazy to me. So briefly to the chat, in case we jumped ahead, I think all of you probably know what we're talking about. But in case we jumped ahead, Fani Willis and Nathan Wade allegedly, no, they did. They had a relationship, an improper relationship during this action. It was not disclosed. It was not properly dealt with, and it created an ethical question called an appearance of impropriety. Those must be dealt with. An appearance of impropriety tends to require two parties acting together because one party is gaining a benefit with the consent of the other, and that benefit and that consent are improper. Okay, so in this case, Fani Willis, first of all, I think the sexual relationship between them when she is the county prosecutor and he is the special prosecutor that she's hired, a special prosecutor being hired for the purpose of having some separation from the political questions, anything. I just think that relationship is improper in general. But ignoring that, what she's doing is she's approving his pay. He bills the county, she approves the paycheck, and then he is paying for vacations and trips with her as part of their relationship. So she's technically enriching herself at the taxpayer's expense. This is a huge problem. There are other issues here as well, but that one kind of got focused on because it's provable. It's showable that money changed hands in a way that was not supposed to. Now, she alleged that she paid him back in cash with no receipts. The best part of this is that the judge said, it seems that both of you lied under oath. So not only does it take two to create an appearance of impropriety, he asserts that it looks like both of them have lied about the relationship under oath, including when it started. And the only evidence that they brought to say it didn't start prior to all of this, which is kind of critical, is them saying, nuh-uh, even though there's actual evidence to suggest that it did. All of this comes down, and the judge says, yeah, here are these two parties acting in concert, both of them seemingly lying under oath to this court, acting without candor, and then specifically Fani Willis making these improper statements in a public speech, which prosecutors just generally shouldn't be talking publicly during the pendency of an action. But all of this stuff happens, and he's like, yeah, but one of you can stay. And it's crazy to think about this. He basically gave the ultimatum. One of you goes or the other one goes. And of course, Nathan Wade bows out after like 2 hours. He's like, no, here's my resignation letter. But this idea that both of them did this, both of them created this scenario, both of them, he's suggested lied about it. And he's like, well, but it's not bad enough to dismiss both of them out. That's silly.
Well, let me read between the lines here, okay? I'm not going to ascribe any ill motive on a judge for political purposes, okay? I don't want to get into the habit of doing that. I mean, I may be admitted only in Mississippi and Tennessee, but you never know. One day I might appear in Georgia pro se, and not pro se, but pro hoc vici, and then stand before this very judge, and this judge wonder, what the heck were you saying on the Rakita show back after this is over? I'm not going to, you know what I mean? You know what I'm saying?
Bring me in to testify as an expert on that, judge. Okay. I'll do it.
All right. But having said that, I think one thing that he asked at the hearing that stood out to me was when he was asking about, okay, does this only apply to this case, or is this impropriety, can that extend to other cases that Miss Fani Willis has prosecuted in times past? In other words, one of the things you have to understand about judges is that they are very, very, very guarded over their judgments. In other words, they want to always protect their judgments from either being on appeal or being set aside or things along those lines, okay? Because it's their stock in trade. I mean, you spend 3 or 4 weeks on a long trial. You get all these opinions in. You make all your motion rulings, and you put in all this time and effort, and you're not getting paid by the hour. You're just a salaried judge. And then the Supreme Court of your state or somebody else says you were wrong and throws it all out, and you've just wasted time you're never going to get back. You don't want that, okay?
And
you want
combine that in with this is a state judge who's elected. So this judge has public political considerations that must be included. This isn't a federal judge who's appointed for life and can only be removed on impeachment.
That's right. But having said that, I think one of the things he may have been concerned was if he gets in court and makes a finding on the record that Fani Willis has committed perjury, or it looks like it, or if he really wanted to, directing the Attorney General of Georgia to make a referral to her because she committed perjury in his court, or something along those lines, then that would have invited every defense attorney in Fulton County and Cobb County and anybody else that has ever had a trial before the Fulton County Court with Fani Willis to come in and want to have some sort of post-conviction relief or some sort of habeas proceeding to try to get their inmate out of jail. And I think his big fear was that if this was a problem with Fani and he made a finding to that end in this case, then what would happen is that it might have some unforeseeable consequences in other cases that he was trying to protect against. Now, I'm not saying that's a right decision, okay, because I think that you have to call the strikes as the ball goes across the plate, okay? I mean, you've got to have those blinders on as best you can. But having said that, to the extent that you do have any discretion, then you need to write your opinion in such a way that it forestalls or prevents any of these types of issues from ever happening. You know what I mean? I think when he writes in his opinion and he starts talking about, well, there's the Georgia legislature can look into this, the ethics commission can look into this, the Georgia State Bar. I think that was kind of an invitation for these people to come in here and look at this and bail me out of this, guys. Let's bail me out of this crack and come after this woman for me so I don't have to make this decision, and open the door. Yeah. And then open the door for every single, gang violence that has happened in this city to be tested in court again later. And then some violent criminal has been released on a technicality because, there may have been a perjurer who was prosecuting, and then that person go and kill someone else later on down the road. I mean, I think he may be kind of thinking along those lines. So if he is thinking of anything that is beyond the four corners of this case, I'm going to give him the benefit of the doubt and say that it's not going to be his own political machinations. I think it's more that he's afraid of the consequences of throwing this prosecutor out vis-a-vis the public in any of these already settled cases.
See, but I see what you're saying, but I have to take issue because I see an alternative here.
Yeah.
And I simply see that the judge can say exactly what he said in the order. Like, the judge went almost as far as saying they perjured themselves.
Mm-hmm.
Went actually said that her statement in front of the church was legally improper, although basically stopped short of saying it was sufficiently prejudicial, which I think is crazy. But he says it, but it is still legally improper. I mean, to me, the state should be held to the standard that legal impropriety means they go, but we have the good faith exemption and all that stuff. So we'll step aside from that. The only things he definitively said about Fani Willis and Nathan Wade are exactly what you're talking about. They only impact this case. They don't go out. Everything else he cuffed a little bit because of the exact reasons. He does not want 100 relitigated cases because she was involved. However, he has the opportunity to do exactly what he did, or even less than what he did, and remove them both from the case, because he came up with the main question is that there's an appearance of impropriety in this case specifically.
He could do that.
He says he could have there, and he could have just said, look, this case this prosecution with this special prosecutor and this county attorney, we have several questions remaining about their relationship that are not sufficiently answered here, but we don't need to get there, because what we have is an appearance of impropriety, and the integrity of this court and the integrity of this prosecution is at risk from their actions, or from their repeated questionable actions, which I think he even said, even if they keep making the wrong actions, that doesn't make it wrong. No, it literally does. And that's where he goes, in this case, with these questions, with this defendant in this type of prosecution, we have an appearance of impropriety that taints the public's perspective of justice in a political climate, and they need to go. This prosecution can continue. This does not have any impact on any other cases that are out there, and any impropriety is limited in testimony to this case. I think he could have made that order, and I think he could have safely protected other cases without having to go any farther into risk. That's my opinion.
One of the things that I've imagined what I would have done if I were the judge, and when I say what I would have done, assuming that I reached the same opinion that he did, which I wouldn't have, but let's just say I did.
Sure.
I would have gone a step further and it would have said, guys, if y'all want to do an interlocutory appeal and take this up right now, I will let you do it. Okay. Now, where I come from here in Mississippi, if you want to do an interlocutory appeal, you can just go straight to the Mississippi Supreme Court within 21 days and ask for an interlocutory appeal. Okay, you got a petition. Right. But I glanced at the Georgia Supreme Court rule. I think it's Rule 30. I don't know for certain. Don't quote me on it. But under the Georgia rule, you got 10 days to ask for an interlocutory appeal. After 10 days after the trial court certifies that it is a suitable question for one of those appeals. So in other words, I don't think they can ask for an interlocutory appeal without getting Judge McAfee to sign off on that. Okay.
Right.
So in that context, if I had been Judge McAfee, I might have said, guys, go ahead and take this up and let's see if they decide, because I wouldn't say this is exactly a case of first impression, but it's pretty darn close, I would think. And I think this is one of those things that, because of the gravity and the moment that it's going to have, not only on the state of Georgia, but the rest of the whole country. I mean, I think the judge should have invited the parties to go ahead and do an interlock and go up to the Supreme Court and let the Supreme Court of Georgia decide some of this stuff,
Yeah, I think so too, especially after the ethics, the county ethics committee decided not to take jurisdiction over her, saying she's a state agent. So therefore it has to go to the state anyway. I think that question, I think he could have granted an interlocutory appeal and said, yeah, go for it. I think that might've been wise, but I don't know. I don't know enough about Georgia process to do that, like to definitively say either way what they would have to do. I don't like this idea. Look, I know judges make bad decisions.
Yeah.
They make them all the time. And judges make good decisions all the time. What I don't like is when judges make illogical decisions. And that's what this struck me as immediately, is like, okay, what you're saying here is that these two people did this thing that makes at least an appearance of impropriety, which must be remedied. Removing one doesn't remove the appearance of impropriety or the taint of either of their actions. Their actions are inextricably tied together. You must remove them both. And I'm not saying, I do agree that from what I've seen, I don't think dismissal of the charges by the judge is the appropriate remedy under the law as it sits, just because dismissal for these types of things is so damn hard to get. I disagree that it should be, but under the law as it stands, it's so hard to get him to dismiss. So I agree with his reasoning there. He says, like, this doesn't rise to dismissal. The defense hasn't shown it sufficiently prejudiced Donald Trump in the way to merit dismissal of the claims, but dismissal of these two, I think, is warranted here. And that's what bothers me, is like all of his reasoning points to both of them needing to go. He's like, well, but one of you can stay. And I'm like, that is completely illogical.
Well, I mean, it's almost like, Okay, let's say I'm an accessory. Let's pretend you and I are accessory to. Let's say we are.
Okay, yeah, I got it.
Let's say you and I are conspiring right now to commit an XYZ crime of some sort. Okay, all right.
Those are the best. Yeah.
Okay, we are conspiring to commit some sort of crime, and let's say you are the trigger man.
Yes.
But I am just the guy who comes up with the idea and makes a couple of phone calls, and and yet they come after me, but let you have the pass.
Right.
I mean, because at the end of the day, yeah, Wade was a special prosecutor, but this is the thing also to consider. It's like you said a while ago, the whole point of a special prosecutor is to create some sort of imprimatur of independence. Okay.
Yep.
But if I'm, doing it with the special prosecutor, there's not any independence there. Okay.
Oh gosh, that's a joke for another day. No, I agree. I 100% agree. There's no independence. It eliminates that illusory wall that exists, because the special prosecutor, I mean, their office is also working with they're working with the county. They're like an insurance policy against the potential political implications that are out there. Like they're a hedge. They're there to say, you know what, I've got your information, and we've got your investigation, all the research and resource gathering that you have, but also this is not where you need to go with this. And that's the purpose. But yeah, when they're railing it out in the Bahamas, there is no wall.
There's no wall. And here's another thing that I think, let's look at the silver lining on this for President Trump for a moment. Okay.
Yeah.
Number one, gosh, I hate saying this because I've been to court, and I've gone to court sometimes where I wasn't quite prepared and I looked like I wasn't on my A game. Then again, there have been times I've come to court and I've actually knocked it out of the park. Okay. The guy who was standing in for the original lady who was the special prosecutor, who ended up disappearing all of a sudden, and we don't know where she's at because she probably got a little bit of
Clinton.
Well, no, she probably got an idea of, hey, maybe I need to not be in this anymore for my own, because I mean, as lawyers, we have ethical duties to make sure we don't put people on the stand that are lying or whatnot. And when all this stuff starts coming up, I would have probably said, hey, I'm getting out of here. See ya. I don't want to mess with this anymore. I value my law license. I value my career. Bye-bye. See ya. I'll go on my way. And I think there's at least the possibility that this attorney in question was doing that. And so they had to put the intra-office bench on, pull them up to start arguing that hearing a few weeks ago and last week. And the guy was using the PowerPoint and all of that and messing a whole bunch of stuff up, and it was just awful. Well, if they have to stay in-house to prosecute this case, I don't think the district attorney's office is going to be able to do an adequate job to go after all of these defendants. Okay. And so they're going to have to hire another special prosecutor to take up where it's happened. But the problem you've got there is, if Wade is gone, and this is it her name, Cross? I can't remember her name. It looks like she's gone. And you might still have the one other guy there who's the RICO expert, who's getting paid, he's getting paid peanuts, if you want to get right down to it, $150 an hour.
Yeah.
And he's an expert on the RICO law. I don't know if he's going to have the trial practice. He may be more of a big picture visionary kind of fella. But if you're going to hire somebody to actually litigate this case, they're going to have to get up to speed on it. And, and I don't know if they're going to have enough time to do that for an election.
They're going to have to get up to speed on $700,000 of billing that Nathan Wade did. There's some, I know he likely overbilled and had some permissive payments, but even if he didn't, I mean, this is 6 figures of work that they now have to catch up on. It's so much reading. It's so much. They have to verify the research. They have to make sure this was, and also considering you're coming in on someone who's just removed for not doing the job that they were supposed to, doing it improperly.
Do you know what would be hilarious?
What's that?
This would just be freaking hilarious. is if Trump and Ashley Merchant and all of them all together, all at once, filed a speedy trial motion.
Am I right to a speedy trial?
I want a speedy trial. And, of course, you've got a new district attorney who's wondering what the heck is going on. A new special counsel or the office there. And, I don't think they would be ready to do it, because I think they had farmed out so much to Wade, letting him do everything, that I don't think there's anybody who, unless you are an avid member of the Democratic Party in Georgia who is a political hack, and I say that as somebody who might be accused of being a political hack on the other side, okay? But, unless you are a political hack who doesn't really care, you're not going to take this case if there is even the hint or the likelihood that you might have your license examined because you put perjured testimony on the stand, or right. What I'm getting at. And if that's the games that they've been playing, Fani and Wade, I mean, if they're playing that hard and fast with the truth, then you got to wonder is what else of their evidence is like that. Okay.
Right. Yeah. I mean, that's the problem with impropriety in these prosecutions, is that if there is impropriety going on, if these checks between the special prosecutor and the state and the attorney's office, county attorney's office, if those aren't happening, if the work is conspiratorially shoddy for the purpose of either boosting their public political profiles, their public professional profiles, or merely reaping free money from the taxpayers, whatever it may be, whatever motivation they may have for prolonging this prosecution that maybe isn't valid. And this is the question is we wouldn't know if they're doing that. The appearance of impropriety says, well, the fact that they might be makes it bad enough. And whatever reason they may have had to do that, now you're walking into this prosecution and you're looking at the work going, oh my God, like, what do I do here? How do we even go on with this? But you have a duty to go on, like that's your job.
Yeah. Well, here's another thought to consider. Okay. Let me throw you out a question.
Okay.
Let's say Nick Rakita, member of the Georgia Bar.
Oh, yes.
Let's say you're a
member.
Say, hi, I'm Nick Rakita. I'm from Plains, Georgia, and I'm an attorney. Okay. For those of you at home, that was a very lame attempt at doing a Jimmy Carter impersonation. And you're asked to be the special prosecutor. Okay. Now, let's assume that Fani is above board and gives you complete discretion because you're the special prosecutor and it's an independent type thing. Okay.
Right.
There would at least be the possibility that this new special prosecutor, whomever he or she might be, might try to nollie the cases and say, okay, we're done, dismiss it, or drop charges.
Right. Yeah,
I mean,
of course.
There's always the possibility for that because, I mean, and this goes back to the whole issue we were talking about before, the pecuniary gain. I mean, if you're billing 24 hours a day on something and you're maxing out your $35,000 a month in income, and you just happen to be having sex with your boss or the person who's paying your bills, you're not concerned. You have no objectivity about the case.
Okay? Right. But because why would you want it? Why would you want it to end?
But if you are a newly appointed special prosecutor who is taking a case over that you're now going to be putting your reputation on, one thing that you're going to want to do is to look through all of these counts of the indictment and try to separate the wheat from the chaff, and maybe drop a few counts to focus on the things that you think you can win, because you've only got 9 months now to do something about it. If that is, you anticipate trying to do this before an election. Okay. Or if you're an above board attorney who's not trying to do this because of political purposes, and you say, well, election be darned. All right. We could set this for trial next year or the year after next. And then if he's president, he's president. If he's not, he's not. We're just going to take the chips where they fall. Okay, that's different. But either way, you're going to evaluate the case on the merits to see if you think there's something here or something that's not here, and you might go ahead and drop some stuff. Okay. Now, given the fact, now here's another thing to consider. The judge did sort of split the baby the other day when he dropped about 6 or 7 counts for President Trump,
right?
On and including the perfect phone call with Rassenberger. Okay.
The whole like impetus for all of this.
Yeah. They're gonna, if they want to recharge them on that, they're gonna have to get another grand jury. I don't know necessarily how that works in Georgia, but the bottom line is that's going to eat up time and take some time up. So I think whoever is going to be taking over this case is going to have to decide that maybe we need to drop some of these charges. Maybe we need to focus on the things that are important and whittle this down, because they got a lot of catching up to do. And it might actually come back to help Trump if you want to get right down to it.
Right. It may. And that was always of course, if he had dismissed both of the prosecutors, there would have been a real chance that this thing drops. But I did want to caution saying that, though, like I said this, I think yesterday or the day before or both. This is President Trump here. And so all of the conventional wisdom about what happens next in any of these moves must be taken skeptically, because what normally happens is not this case. Like, what normally happens is not the prosecution of a former president for election interference based on a phone call that has now been dismissed. We don't know what the next thing will be, because there's so many different motivations than what is typically at play. And I think that, again, I think that alone makes all of this interesting. That's why I love talking about this stuff. But Matt, I do have to say, it's been almost 3 hours.
Mm-hmm.
And I need to read chats and go to bed.
Okay.
Would you like to hang out for that, or would you like to head to bed on your own while I take care of that? I know it's been a long night. So
I've got 18% left on my battery. I had it at about 98% when I was 94, 95% when we started talking 3 hours ago. I got to get up early morning tomorrow to go to this 10K run for my daughter. By the way, let me tell you, I got to brag on my daughter. Can I tell you something real quick about my daughter? So back in 2020, she woke up one morning feeling like she had like the symptoms of COVID or something. And so we decided to take her to a clinic for a test. And when we went to this clinic, the nurse practitioner says, okay, we're going to give your daughter an x-ray just to make sure that, there's nothing there. And if it turns out there is nothing there, then we've got a baseline just in case later you do get it. We can compare, just basically they needed an x-ray. So they walked my then 12-year-old daughter back to get an x-ray, and I'm waiting in the room, and she comes back and she looks at me and she says, 12 years old now. She looks at me and says, Dad, I looked at my x-ray and I think I've got scoliosis.
Oh.
And I looked at her and I says, "No, listen, Natalie, look. The human spine is not perfectly straight. It's going to have kind of a curve in it. I mean, you're just overthinking it." Nurse comes in about 20 minutes later and she said, "Well, I've got some good news and some bad news. The good news is you don't have COVID. But the bad news is you have a severe case of scoliosis." And I looked at my daughter, I kid you not, and I high-fived her because she diagnosed her I was proud of her for diagnosing her thing.
Nailed it.
Well, anyway, she ended up having to have 2 complete spinal fusion rods all the way down her back. So she had spinal fusion surgery a week after the election in 2020. And the surgery, I think, happened on a Monday, and by Thursday, she's walking around. I mean, back when we were kids, they had to put you in a cast and you would be there for months. Oh, sure. No. Now it's like, we're walking you around, pal. We got you getting you ready.
That's crazy.
And so she got into the habit of just starting to just walk every day.
Mm-hmm.
And we moved. We changed towns. We now live up in Tupelo, Mississippi, and we got involved in a homeschool group where she's now running track, and she's just loving it. And a few months ago, January, in fact, she got ready to run her first half marathon. Okay.
Awesome, man.
Well, we had a big ice storm right before the half marathon, and she couldn't run. And our neighborhood is in a square, and the square is about a third of a mile. She can run 3 laps for a mile, right?
Mm-hmm.
And she was just had such cabin fever because it's like, I gotta run, I gotta get some miles in so I can practice for my run. And one day during that ice storm, she just got so frustrated, and she just literally, she went and got a shovel. She went out to the street, and she literally shoveled a path around the entire neighborhood on the street, and then ran 12 miles.
Jeez. Oh, that's too much ambition for my taste.
Well, anyway, I said that, and she did her half marathon, and she was first in her age group. Well, tomorrow, we're down here in Jackson because the hospital that did the back surgery for her is having a fun run type fundraiser. And so she's so excited about doing a 10K run. She's not going to do the half marathon this time because she's in track and she doesn't want to overexert herself. But so that's why we're here. That's why I'm in a room in the hotel. If you're looking at the back and you see all these boxes, it's because they let me come into this conference room, and there's a whole bunch of boxes already in here. And so I thought, well, just as well as any. So yeah. I'm going to leave it with you just to say that I'm going to go upstairs and try to get a little bit of sleep before we get up and go do this fun run. And besides, my battery's about out, but I had to use this time to brag on my daughter. And
absolutely,
and it's been a pleasure, Nick. I've enjoyed 3 hours of chatting with you. Maybe we can do this again some other time.
It's always fun. We need to do it more frequently than the last gap. So that's on me, of course.
Well, I thought it might have been, because there's a couple of times during the the Kyle Rittenhouse saga where, I don't know, I might have moved my hand and my finger up to my nose in the wrong time and place, and made a fool of myself on
very critical
television.
of you. Yeah, definitely.
And the fact that I'm like balancing my trust account while I'm listening to you, I don't know, just didn't look too professional. I don't know. I thought maybe you were just, at any rate. So, but listen, thank you so much for having me on your show tonight. I've enjoyed it.
Yeah, man, it's been fantastic. I love the conversation, love the topics. We'll talk more. Blessings to you and your family. Please pass along my well wishes to your daughter. I hope she does great tomorrow. I know you'll be a proud dad wherever she ends up. Thanks for hanging out with me, buddy. We'll talk soon.
10-4. Have a good night.
All right, peace. All right, I'll let him exit out. Okay, guys, it's been 3 hours. That was great. Great discussion. So much topics I really like talking about, but are also like not just goofy and silly. Like, they're fun and also educational or something. Maybe when you've got a guy as smart as Matt on, they're very educational, and you have me, and I can sometimes ask a good question or two. But it is really late. I'm going to go through the chats on both YouTube and Rumble. I decided the conversation was going really well, and the Rumble flip is really awkward during an interview like that. So I decided to just keep going on both channels and let people watch without interrupting it. And I really liked the show and the conversation tonight. So we just went through with that, which is great. I'll pay my respects to the masters later, but no. So this will be up in full on both channels. Thank you guys for watching. I'm going to read all of the chats, also the locals chats, everything that we've got. And then I'm going to go to bed right after that, because my own kids have stuff going on tomorrow that I'm very proud of. They didn't like shovel a third of a mile path around a neighborhood through an ice storm and then run 12 miles. But then they're doing some like a drama production, which is cool. But yeah, I've got to help them get ready for that in the morning-ish. So we're going to wrap up as soon as we get through the chats, and we'll go from there. First, I have to give a big shout out to the biggest fan of the show, Richard O Team, which is a weirdo. He says, "Is this one of the cucks you get to fuck? Haha, just kidding. It's all fun and cuck games." I don't know if you understand the terms you used, but yes. Richard O Team also says, "Nick, Monty has always been into sucking little boy cock, which is weird, but that's his thing. Look, I'm not here to stop him. I'm just saying he should probably be shot in the fucking head, Montegraph." I don't know why. Why would you? Okay. Well, see, I guess you just corroborated it. That's cool. Richard O Team says, and Nick goes on, "Look, I'm not here to stop him. I'm just saying he should probably be shot in the fucking head. Montegraph, you're a fucking figgot. Everybody knows you're a figgot. Clip this all, yo. Dude, these are harsh words. I don't know what you're talking about, but he also says, Richard O. Team says, Nick said, and I quote, look, I'm not here to stop him. I'm just saying he should probably be shot. And no, Nick did nothing wrong. Okay. Thanks for sending me money. Real Ty Beard says, I felt a grave disturbance in the force. Yes, you did, Ty. That was just me belching. Jarvia's, me sneezing would have killed you. Jarvia says, question, if the Chief Justice refuses to preside, is that a de facto veto of an impeachment trial? I don't know. We don't know how to resolve that question, and it's really weird. But maybe SC Medic 71 says, don't feel bad. Several of us support nuking Canada. Yes. Cack and Bulls says, are you from Kentucky? No, he's from Mississippi. Darth Bender says, hi, Nick. Hope you're well. Thank you. I am. Grifty says, does Matt have an affinity for cantaloupe? Sorry, I know I'm an asshole, but it's the voice. All love. Kitra says, can I get a toast for my cyber law exam of 101 via bonus essay that screwed the curve? It's my first exam since my gap for passing, for the passing of 6 family within 3 months. Oh my gosh. You really helped me with the material. Thus, I am grateful. Kitra, yes. Yes, I will get a toast to your cyber law exam. Let me just get a little brother justice whiskey here for your toast. Cheers, Kitra, to your cyber law exam. I guess you got a score of 101 via a bonus essay. So cheers to that. Fantastic job. Man, I am so glad I never have to do any of that ever again. Cheers. WSX says America needs 100 Matthew Wilsons, and I'm being modest. Oh, dude, guy's great, smart, sharp, hardworking, all of the good stuff. Seize the Day says toast to the freedom fighters coming out in all their different roles to stand up and speak. God, good, and sends his army. Romans 12:19 in real time. Cheers. What he said. Malcolm McKee says, I didn't realize Ted Cruz was a master of disguise. Pony Up says, Biden, greatest shitting president. Jenny LJ gifted 10 memberships. Thank you, Jenny. Lover of Green says, why are people still doing the Fauci nonsense? Well, I don't know. The U.S. health mandates ended because of court decisions. Plus, most people got tired of them. Yet face napkins are a thing in 2024. It's legal, but also stupid. Dude, I saw people wearing masks the other day, and I was like, why is this thing still happening? I didn't know. Watermark says, I remember Matt. Good to have him back, Nick. Yeah, me. I remember him too, and I agree. Choosy Heretics Choose Carnation Revolution Now says, blow answer in my name. Blow. Okay. Seize the Day says, does Nick know you're reading the super chats? No, he did. No, I did not. John Jelaine says, lawfare premeditated crime. Well, lawfare isn't a crime. But it would be premeditated necessarily, I suppose. Nasir says, judge did the Comey dodge, guilty, but this is a white judge in Wakanda. How else he finna rule? Damn. He says, so she's spineless like the judge. I think he was talking about Mazar. She has a spine. It was just twisted or crooked or whatever. Nasir says, the bow tie looks very professional. Hashtag not gay. Reformed Convict says, did you see Jack Murphy is making a comeback? There's jokes about coming back. And Nazir says, Rich is a fan of cantaloupe and taking pics of kids. Whoa. Rich? Who's Rich? And then finally, over on locals, we have from Sally. She has a Gives and Go for kidney campaign. My friend and one of your supporters for over a year and a half needs kidneys. Please share the Gives and Go. Sally, I will share this in locals. I will share it on Rumble and YouTube as well. But please, if you could, send that to me personally so I can share it on the show Monday as well. I'm trying to make sure everybody gets this, but I have to get out of here. So everybody can click on that. We'll do a more, Sally, talk to me about this over the weekend so I can properly talk about it on Monday. I'd be happy to help out with that, but I need to get going to bed tonight. And plus people are on the way out. So I want to give it a proper look and show people what's going on with that, guys. Thanks for hanging out tonight. We'll see you probably Monday, most likely Monday. But keep watch, recadalaw.locals.com for any show announcements. It's free to sign up for that. Go check it out there, and we'll talk very soon. Hope you guys have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that brogue. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed